we're going to get ready, and I will let you know when you're free to proceed.
Thank you.
You're free to proceed.
Thank you. I would like to call to order this virtual special meeting of the Rehoboth Beach Planning Commission on Friday, February 26th, 2021, and at 11:01. So will the secretary please call the roll? Lee, you're muted.
Bryan.
Mike Bryan's here.
Mr. Covington.
Here.
Mr. Kaufman.
Present.
Ms. Lucier.
Here.
Ms. Macha. Ms. Macha is not present. Mr. Patterson.
Here.
Mr. Strange.
I'm here, thank you.
Myself and Mr. Trunzo.
Okay, all here. Thank you so much. Ms. Macha has recused herself from matters of clear space. Verification of meeting notice. Ms. Womack?
Can you hear me?
Yes.
Okay. The agenda was posted in City Hall and on the city portal on February 17th, 2021, and was sent out from the portal on the same day. Chairman, that's all I have.
Thank you so much. And of correspondence?
We have correspondence that has come in, but it's particular to the items listed on the agenda.
Yes, thank you so much. Okay, so as everyone knows, the purpose of this special meeting is a continuation of the public hearings for site plan review of the applications for clear space and Rehoboth Spotlight. I have some introductory remarks today that I'll go through. So I'd like to welcome all participants to this continuation of the public hearings of site plan review applications for Clear Space Theater and Rehoboth Spotlight. I request patience due to the obstacles involved with conducting a public hearing with participants remotely located. And the city secretary reminds me to please ask everyone not to talk over each other. We appreciate that. Also, for the record, I'd like everyone to know that Ms. Macha informed the chair on February 16th, 2021, that she's recusing herself from the Clear Space Theater and Rehoboth Spotlight site review plans. And properly is the first matter. I want to thank everyone for staying involved and active in these site plan reviews. The level of engagement has been astounding, and at times I felt almost overwhelming. The PC has dealt with uncertainty and surprises and maintained their impartiality and collegiality. I thank my PC colleagues for their many helpful suggestions and support. I also want to thank the PC officers for contributing heavily to the preparation and follow-up to our meetings and making the meetings successful. I could not have done it without them. I'll say that. So the city staff and management has worked on multiple tasks to support the PC, including these site plans, other projects we reviewed, the considerable correspondence flows, and also work behind the scenes for the CDP and preparing our pivot to that. It takes a lot of staff time and effort to support the PC, and we're very grateful. Our elected officials have expressed their support and allow us our independence to do our job well. We thank the applicant for bringing these site plan review applications and for recognizing the qualities that make Rehoboth Beach a good place to locate. And most importantly, we thank city residents and stakeholders who share their passion and talents to continue to make Rehoboth Beach the great place that it is. We appreciate all of you. So after the conclusion of the successful public hearings on Friday, January 29th, 2021, for Clear Space Theater and Rehoboth Spotlight, it has been a month, the PC pivoted to the public deliberation phase of the site plan review process. The PC continued the public deliberation at the February 12th, 2021 meeting, making substantial progress, and scheduled today's special virtual meeting to continue the public deliberation. The PC chair, officers, and members all intend to conclude these public hearings with a decision as soon as possible. And I anticipate with the preparation everyone has done, we may be able to conclude this matter with a vote today. I trust that the applicant agrees and supports this goal. Whether the deliberation is completed or not today, we will conclude the site plan deliberation around 4 p.m. to allow time for the remainder of the agenda items, including public comments and the scheduling of an additional meeting should it be necessary. Today's hearing will adjourn by 4:30 p.m. We will take a 30-minute break at the appropriate time between 12:30 and 1 p.m. So the staff may have their time to regroup and support us. So the process we introduced at the February 12th meeting will continue today. The vice chair took the lead with editing and revising a draft resolution incorporating a range of possible conditions, and the vice chair consulted with the PC officers and the city solicitor about the language. This is the work tool to allow us to deliberate the site plan under section 23630 effectively and efficiently in view of the city of Rehoboth Beach's comprehensive development plan, chapter 270 of the city code, this chapter, and other applicable federal, state, county, and city laws and regulations. Additionally, the PC shall consider the 21 factors in section 236-30E of the site plan review. This working document was provided to the PC in advance of today's meeting and placed in the city's document center. The work tool being used is necessary due to the complexity and number of issues being discussed. It does not assume that these site plan applications will or will not be ultimately approved by the Planning Commission. Its only purpose is to provide logical clarity and completeness of documentation for the application. When the PC deliberation is complete, a motion may be made to approve subject to changes or conditions, or deny the site plan review application. Such motion may be amended and straw votes may be taken on retaining, eliminating, or modifying specific changes or conditions. When no further amendments are offered, the chair will call for the vote. The secretary will call the roll in alphabetical order. Each member will state their vote and provide their justification for the vote for the record. The chair will vote last. The resolutions will be finalized within a few business days after the decision to allow time for editing and review for accuracy. So I will say now, before we get into the order of business, to the PC members and city solicitors, any comments or questions or matters to address before we pivot to today's order of business? Ms. Lucier, you're muted. You need to unmute. Go ahead.
Is that okay?
Yes.
Okay, thank you. I would like to make a motion, and I'm doing so because there have been allegations of improper actions. And I feel as if, since they have been made public today by the Cape Gazette, in the spirit of transparency, I feel that we should address the issue before we proceed. And I do this to protect the process and also to protect the credibility and reputation of the Planning Commission, of our council, Mr. Mendalis, of the city, and also of ClearSpace. The allegations deserve open discussion and action by the Planning Commission. And my motion is that I move that the Planning Commission disengage the services of Mr. Mendalis to further advise us or to participate in our proceedings involving ClearSpace and Rehoboth Spotlight because of unresolved issues regarding the filing of a PIC complaint by John Swift.
Thank you, Ms. Lucier. So we have a motion by Ms. Lucier. Is there a second?
Sure, I'll second too.
Okay, so we have a second from Mr. Patterson. So I think we should proceed to hear from the planning commissioners about what they think of this motion. So would anyone like to go next? Mr. Kaufman, I see your hand.
Thank you. Hold on a second. I need a minute. Why don't you come back to me?
Okay, we'll come back to you. Anyone else? Mr. Patterson.
Thanks, Chair. So yeah, I second for purpose of discussion. I hadn't actually seen the Cape Gazette today, but you know, as an in-house counsel to an institutional governmental client myself, I do understand the difficulty that lawyers have when advising institutional clients and operating what can be a gray area between the client as an institution, such as this planning commission and the city as a whole, and individual representatives of the client, individual officers, employees, or members of this commission. And I don't think that we have nearly sufficient information in front of us to pass judgment on Mr. Swift's allegation. And but just as importantly, I don't think it really matters to our process today, even if someone's opportunity to be heard was affected by events in the past. The public hearing is closed and we're deliberating. And so our deliberations are not affected by those issues. And I don't see how Mr. Mandel is not assisting us through these deliberations is to our benefit. I don't see how it would address Mr. Swift's concern at this stage.
Thank you, Mr. Patterson. Mr. Kaufman, are you ready now? And then we'll
Yes,
go to
I am.
Mr. Strange.
Yes, thank you. I oppose this motion. I don't think we have appropriate authority to even make this motion. It is not up to us. This is a matter for the city commissioners. Mr. Mandalis has a contract as the city solicitor, and as part of that, he is our counsel. If there is a complaint against Mr. Mandalis, there are appropriate places within the State Bar Association for a complaint with regard to ethics to be made. We do not have jurisdiction to make such a motion or to pass it. It is not for us to decide. Mr. Mandalis is our counsel until told otherwise, either by the city commissioners or by the State Bar Association. I believe a lot of this has to do with character assassination. I'm very upset by it. I think this is not the appropriate way for people to proceed in Rehoboth Beach and to try to character assassinate people. What I view this as.
Is that it,
That's all I
Mr.
have to say.
Okay, thank you, Mr. Kaufman.
For
Mr.
now.
For now, Mr. Strange.
Yeah, my question was if we voted in the affirmative for this, how could we proceed if we didn't have legal counsel here today?
Well, I could say a few remarks because I have been, along with the vice chair, we have been following along. I guess I need to provide some background. When the complaint came, I thought there was a limited number of people on it and it was not distributed in the first few hours to the chair. I then received phone calls, which confused me thoroughly. I'm sorry about that. But then I realized separate messages went and parties were not copied on the other messages. So I left you all hanging because I didn't think you had the information. So, you know, then I caught up with the evaluation, had a discussion with Mr. Mandalis. He told me how seriously he took the complaint and what measures he had gone to get advice and what his opinion was. And I'm comfortable with everything he says. I'll also go a little bit further, is that Mr. Swift's letter describes a period of time when I was in the same space as Mr. Mandelis, our January meeting. He told me that he was working between some of the parties, and I overheard the conversation. So, of course, I didn't hear what was on the other side of the phone, but nothing gives me any reason to believe that there is a reason for concern with how Mr. Mandelis attempted to resolve a last-minute situation so that we could proceed, which was my utmost concern expressing to him at the time. So, I don't know how other people would view it, but I saw no threats, I saw no craziness, I saw no pressure applied. I saw some mediation trying to bring parties together. So I did have the benefit of that. So I have a view that other people may not have. So without Mr. Mandelis today at this very important meeting, I cannot imagine how we could proceed. We would have to cancel and delay. I would be willing to have a discussion with the attorney members of the PC to see if collectively we could cover everything that he would cover, but I don't know that anyone has that deep knowledge of the city that we would be able to have that perspective. So I would be very concerned if he's not here. I would feel a very strong urge to reschedule, if that answers your question.
Yes, it does.
Mr. Bryan?
You're muted.
Still muted.
Mike,
I call for the question, please. Can we move forward to vote so we can continue this hearing?
All right, so we have a call to vote. Has everyone spoken who wants to speak? Okay, go ahead, Mr. Lucier.
Yeah, no, I just have a question, Jeff. My understanding from the reading was this was emails. You're saying that these were phone calls?
I do not have access to any emails that would illuminate that.
No, but you said when you were there, it was phone calls the day of the meeting.
Before and during the meeting, we were in City Hall together that day.
Right.
Yeah, and I knew that those issues were under discussion.
On the phone. My understanding
phone.
from the reading was okay. That's different than what.
That they could have referenced another time. There could have been there. This is what Mr. Kaufman was talking about. We don't have the picture of everything, but I know there was discussion amongst those parties going on, and I saw part of it. That's all. Okay, so we're ready to vote. Now, I want to get this right. So someone help me with the motion again. So we get the vote correct. Joyce, would you like to state the part that is the action part?
Oh, wait, I don't have it now.
So a yes vote would be a vote to remove me.
Yeah, the vote is to remove from today's discussion.
Okay, very good. So everyone understands that. If we vote yes, that's to remove Mr. Mandelis. So, Mr. Kaufman, please.
yeah, I had one other thing I wanted to add.
Okay.
I view all of this as a dilatory tactic to deny this applicant a fair hearing and a decision. This applicant deserves a decision. It deserves a decision today. All these things that have happened recently, I view generally as dilatory tactics to slow down and proceeding to a decision on the merits. Yes or no, we need to do that. Thank you.
Okay, so the motion is for the PC to remove Mr. Mandelis from these proceedings. So all in favor? We have a yes vote for Ms. Lucier. All opposed? It looks like everybody else has voted no. Oh, I'm sorry. Everyone else has voted no. And then any abstentions? And one abstention from Mr. Strain. Thank you, everybody. I think it's helpful to get that out in the open and do the best we can with it.
Thank you, Jeff.
I appreciate you bringing it forward, Joyce.
Thank you.
Mr. Chair, if I could just say
Please.
that, look, doing what I do, your skin gets thick. So I'm not at all offended by the motion. I hope Mr. Sarah realizes that. But I'm here intending to get to the best decision we can make that is legally sustainable. So let's get to it.
Thank you.
Okay. So that moves us forward. Shuffle my papers here for a minute. So now I have very short comments about today's order of business, and hopefully this will provide some clarity again. So the order of business today, we resumed the February 12th deliberations regarding the site plan reviews for Clear Space Theater and Rehoboth Spotlight. In continuance of these deliberations, we will pick up where we left off on the discussion of the draft resolution workflow, starting with the additional design clarification section. We will then discuss the traffic and parking conditions before circling back to the revisions in the noise, lighting, and use manual. Today is for the PC to continue its deliberations. It is not an opportunity for the record to be supplemented by the applicants or the public. In the event that the PC has a question, the answer to which being necessary to its decision-making process, we will exhaust every avenue, including looking to city staff, before looking to the applicant to point us to something in the record. In instances where the question is not essential to our decision-making, the question may be left unanswered. If necessary, we may take several straw votes to determine the support for a condition before deciding to retain, eliminate, or modify the condition. After we have completed our discussion of every section of the work tool and have agreed upon a draft resolution, the chair will ask if anyone is ready to propose a motion and ask if there is a second. If there is a second, the chair will ask if any member wishes to offer an amendment to the motion. Any amendment offered will be explained, discussed, and voted on individually to include or exclude in the motion. The amendment process will continue until no more amendments are offered. At the point where no further amendments are offered, the chair will call for the vote of the motion as amended, and the secretary will call the roll in alphabetical order. The chair will vote last. As each member is called, they should state their vote and then their reasoning for voting the way they did for the record. The chair will announce the results of the vote. The resolutions will be administratively finalized within a few business days after the decision to allow for editing and reviewing for accuracy. The chair will announce the conclusion of the public hearing for the site plan review. Okay, at this point, I've said everything that I wrote down. Are we ready to begin? Are there any procedural questions? Mr. Kaufman. You need to unmute again, sir.
It seems to me that for the most part, in terms of this working document, all the whereases and the first 5 conditions are not are in agreement with everyone. So I propose that we proceed with the conditions thereafter, starting with condition number 6, because the first part appears to be correct, and that I don't believe there's any opposition. Secondly, in this document, the application number for the second portion of this, dealing with not Clear Spaces Theater, but the other piece, I don't believe the number is correct. It says application 0620-03. This is 03. That the second application is 03. I think it's maybe 02. I'm not sure what the number is. I wonder if we can have some clarification there.
Yeah, we'll go to Mr. Patterson shortly, and he may have additional information. I think some of the information up front in the findings may also be a discussion item, but we'll certainly get all those administrative things cleared, straightened out.
So unless there's an issue with any of the whereases or the first 5 conditions, in the interest of time, I would suggest that we start with number 6.
Yeah, so I have something further to say that I should have said earlier too, that Police Chief Banks is with us, and he is with us now, and his availability may be limited. He has many responsibilities, so we may or may not want to go to the sections for which he's involved: traffic, parking, and safety, to make good use of his time. So I'm just leaving that as an open item. But if there are no other questions, Chief Banks is on camera. Can you tell us a bit about your schedule?
Hi, good morning. Thank you, Chair. I was just going to relay that I have cleared my schedule, so I'm okay to listen in, and I'll just advise when you have any questions.
Wonderful. So, Mr. Patterson, can I hand it off to you now?
Thanks, Chair. Yeah, so let me add a couple of preliminary points, and I recognize what Mr. Kaufman said about the things that are agreed. I do believe we should not belabor those points. And as far as the application number, and that we can, we'll take another look at that. The plan here is we're working off of a single tool, and because most of these whereas clauses and findings and conditions will apply equally to both applications. And I've tried to indicate the ones that I think will only apply to one or the other. And then maybe at the lunch break, we'll have a chance to sort this out more properly. But the idea is we ultimately vote, we will vote on one or the other. And even if we don't have the 2 documents in front of us in final form, and that will be part of the final administrative cleanup that we'll need to do after today. The document you should have in front of you should stay in the heading on the first page, at least, clean version February 22, 2021. And I regret that the headings don't always say that. And I also regret that the earlier version I circulated a couple weeks ago had the wrong date on it because my fat fingers hit 22 instead of 11 on that version. So, but just in case there's any doubt, this version we're working on, which is the one that's on the portal, on the last page, it's page number 9, and the number of numbered lines in the document is 385. So that's the one I'm going to be using if we reference line number document.
Thank you.
Now, because we spent so much time last time on noise and lighting and the permitted uses questions, and there was a fair amount of comment after the meeting while the comment period was still open about, well, we didn't get to things like traffic and parking and the floor area questions. I would suggest that we start with those other topics, the traffic, parking, and then that will also use, hopefully, Chief Banks. That would be where he might have interventions. He has to be pulled away from other things. Another preliminary point is you may have noticed in recent days we have been receiving the usual fire hose of information from the public and information from the applicants. And I think there's even more of that information that you have not yet seen because the chair or the officers and Ann have simply not been able to get to it all in the last 24 hours when we were preparing for this meeting and also doing our regular jobs. The important point, though, I wanted to make was from what I have seen so far, which is most of it, this material is redundant of things we already have in the public record. It's additional commentary and, reacting to our discussion last time, but it is material we already received. I think we understand it from previous comments by the public and the applicant. And so while we shouldn't be relying on these sort of late submitted material, the redundancy means we don't need to, I think. And but to be transparent, we are posting it when we can. So just to assure members of the public. And so if we turn first to the parking, traffic, and pedestrian safety issues, that's on starts on page 6 of my document, and with condition 19. So just to recall, section 23630 requires us to consider 21 factors over and above the minimum requirements of the zoning code and the CDP and other law. And among those factors are things like vehicular traffic flow, access to structures, pedestrian movement, impact on nearby properties and neighborhoods, and other public health, safety, and welfare concerns. So this condition number 19 actually has 4 alternates, 4 possible ways of addressing the traffic concerns, the concerns about traffic on Rehoboth Avenue, traffic and parking impacts in the neighborhoods, pedestrian safety, and related concerns. To summarize, alternates A and B are quite similar. Alternate A is a bit more proscriptive. Both of these alternates A and B seek to make the applicants responsible to some extent in collaboration with the city for managing these impacts created by the development. Alternate A requires the applicants to enter into a traffic and parking mitigation agreement with the city, whereas alternate B requires the applicant to have a plan that is approved by the city. And this is maybe a nuanced difference, goes to the extent of the city's leverage and ability to enforce. Both alternates specify what the plan or agreement should address. Again, alternate A is a bit more proscriptive. And each alternate has a list of potential measures. But note the list, the lettered list is not mandatory, it's indicative. Both alternates say the measures may include these things. So, so that's a difference between both A and B on the one hand and alternate C. Alternate C is the most prescriptive of all 4 alternates. It specifically requires the applicant to do something very specific, the securing of the number of parking spaces before the start of the summer season. That same concept is included as a possibility in alternate A, but just as a suggestion, it's not a commandment in alternate A. And lastly, alternate D, which can stand on its own, or it could be adopted in combination with any of these others, requires the communications from the applicant to mitigate traffic and parking impacts. And then in addition to these 4 alternates in condition 19, there's condition 20, which would establish a process for a kind of trilateral consultation among the applicants, the city, and the neighbors to help identify and address issues of concern of this nature, and also including noise and lighting, and to work through those concerns once the project is completed and operational. So with that introduction, my suggestion is we could start at the bottom of the list and work our way backward. In other words, on number 20, this trilateral process, any comments, questions, or objections to including it? Mr. Bryan.
Yes, I don't think it should be included. These folks have tried mediation. This has gone on forever and ever. I think trying to force them to sit down together is not a good idea. I can't imagine anything good would come of it.
Mr. Covington?
I agree with Mr. Bryan. We've already seen it going forward the last couple of months, people trying to stop this process, and I think it'd be a horrible condition or situation to be in.
Does anyone else wish to comment? Mr. Strange?
Yes, Brian, I want to make sure I understand that notwithstanding the public piece of the recommendation, that the recommendations related to the city making decisions would still be appropriate. Is that the situation?
Specifically about number 20, that number 20 is the one that sets up this process. And then I'll work backward to the number 19 with the 4 alternates. So we're only at this point discussing whether there should be a requirement in here, number 20, that that the city manager, the applicant, and the neighbors meet and confer. Of course, the city manager can meet with the applicants whenever they will meet with her, but to address issues that are bilateral, I think the idea here was to create space for the neighbors to express concerns.
Okay, in that case, I think that I would agree with what Mike Bryan said, that it's been gone over many times, and I think it's our obligation to represent the public at this point. But I do think it's appropriate for those aspects, particularly related to the items you've identified with regard to parking and traffic, that those explicitly may need to be negotiated explicitly with terms and conditions with the city as an entity.
I think we had Mr. Weber and then Mr. Kaufman. Mr. Weber, you're still muted.
I drafted some of this condition, and I think the purpose of it was to set up a procedure after the building is occupied. This is not prior to the plan being approved. And the purpose of it was to kind of set a venue for whether it's the city or clear space or neighbors to have official forum to discuss issues that may come up in an effort to maybe prevent, letters to the editor every week or 15 phone calls to the city manager's office every day about something that might come up, so that there's an official forum for individuals that are affected to have a discussion. And as you see, it burns off pretty quickly. It's 4 times during the first year, 2 times during the second year, and then once in the third year. And then maybe, once everything is ironed out and smoothed out, it doesn't occur anymore. I think it was more of just a way, a formal process for discussing issues rather than it being kind of haphazard phone calls from different people. And the city manager I'm sure doesn't want to get the phone calls from different people with different issues. And so that was kind of the purpose of it, if that helps anybody.
Yeah, I'd like to add on to Mr. Weber's comments. I viewed it, I don't think we have it worded correctly, because we do want it, it's supposed to be an operational review. After the building is up and operating, these parties have data or anecdotes to discuss. And I like the idea of keeping everybody, letting everybody have a voice, and knowing that they have an opportunity to say something in the future to work out unexpected things. So that's my view. Mr. Kaufman? Mr. Kaufman, go ahead.
You're muted, Steve.
Here I am. Okay. Thank you, Jeff, and thank you, Mike. Yeah, my understanding was the same as Jeff's and Lee's. This would be something that would be a way for a liaison of to address any issues arise after, assuming there is approval and it's constructed. After the theater is constructed, the theaters are constructed to handle any issues that should come up during the first and second years of operation. I'm okay with not including it, but my personal practice, I've found that it has helped in controversial cases once it processes forward to avoid, unnecessary complaints. That's all. Thanks.
Thanks, Mr. Kaufman. Mr. Covington?
Yeah, I mean, the concept is admirable, and I'd say under normal circumstances, there'd be a good thing to put it in, but the acrimony has been demonstrated by some of these neighbors. I think it's just going to lead to more conflict to make a requirement here. I'm not sure what's going to get served. And if it weren't for the acrimony, it's been demonstrated so far, I would say yes, but considering the acrimony has been demonstrated, I have to say would oppose to it.
Anyone else? So I'm thinking maybe we should take our first straw vote. What do you think, Mr. Patterson?
I think that's fair. Minimize discussion, retreading the whole issue later.
Okay, so why don't we try this? So, well, how about I ask someone to construct a motion and try to word it in the affirmative? How's that?
Yeah, so I can say I would move to include condition number 20 in the approval resolution. And if this fails by no votes, that means it will be not included.
Okay, great. Everybody's okay with that? Let's have the vote. So all in favor of including this, please say yes.
Did anybody second the vote?
Oh, I'm sorry. Thank you so much. This is why we need Mr. Mandelas. Okay, Mr. Patterson made a motion. Is there a second to that motion? Okay, Mr. Weber has second. Thank you so much. Now we'll have a vote. So the motion is to move to include this condition 20. All in favor? Okay, so we have Mr. Kaufman, Mr. Patterson, Mr. Weber, Ms. Lucier, and myself. All opposed? Mr. Bryant, Mr. Covington, and any abstentions? Mr. Strange. Okay, very good. So we are going to include this, perhaps with some wordsmithing to make sure that it's post-operational matters. Great. Thanks, everybody.
Okay, thank you, Chair. So now moving to the 4 alternates in condition 19. I said earlier that alternate D, it really can stand on its own if it was the only alternate we included, or it could go in combination with any of the other 3. So I would suggest we first tackle D. Are there any objections to including alternate D or any questions?
Could you actually read alternate D?
Yeah, I think so,
please?
for the public to hear it. Yeah.
Sure, yeah. So alternate D, we can read because it's brief. Says, applicant shall direct patrons to alternate means of access, including transit, walking, cycling, and ride-sharing services, and shall direct patrons to alternate routes of access other than Rehoboth Avenue, including State Road or Bayard Avenue, and shall provide messaging to reduce peak traffic congestion at show start and end times, such as developing programs with Main Street, encouraging patrons arrive early and stay late to stroll, shop, and dine. So the intent here is through communication to address parking and traffic congestion issues.
I don't see any hands going up. Mr. Weber.
With respect to alternate C, it's my feeling that the requirement to provide off-site parking is unreasonable. And it's effectively a no to the application because the applicant can't guarantee that they can secure off-site parking spaces. So, and I think the same, I'll just jump ahead and I have the same comment on an alternate A. So what I would recommend is that we take alternate B and as written, and then add a D I, and just insert alternate D as DIII. So kind of as Brian had mentioned, consolidate it basically into one condition, where alternate D is triple I at the end of alternate B.
Did just a clarifying question? Did I think I may have lost the train of thought. I thought we were considering D as a standalone to insert in any of the other.
Well, that's what I'm suggesting, that we take alternate B and add alternate D to it as an additional triple I at the end of alternate B. That makes sense?
I'm not there yet, sorry.
Yeah, so I think I understand. So these,
okay.
If you're looking at that page 8, just take alternate D and slide it up as triple I of alternate B.
right. So what the effect of that would be is, whereas D as drafted, it's a mandatory condition. They shall make these communications. If we put it at the end of B, a list, because that's just an indicative list, things that the applicant may put into their plan for city approval, it's possible the applicant may not include it in their plan and may not have to do it. So that's the difference of structuring it that way.
Any other hands? Mr. Kaufman?
Yeah, so since we're talking about B, that should be read into the record as well. Okay. Could you do that, Brian?
Sure. So B says, recognizing that the intensity of use proposed for this site may have the potential to create risks of severe impacts, especially at times of peak seasonal traffic congestion, to the traffic on the city's primary vehicular route of ingress and egress, to pedestrian and bicyclist safety on streets surrounding the site, and to traffic and parking in the surrounding residential neighborhoods. Prior to opening for business, applicant shall enter into a traffic and parking mitigation plan, subject to the reasonable approval of the city manager. Such plan shall require the applicant to implement effective traffic mitigation measures resulting from the potential impact of applicants' patrons dropping off or picking up individuals in close proximity to applicant's property. Such plan shall also address safe pedestrian access to and from the applicant's property, the potential for pedestrian traffic conflicts resulting from the operation of applicant's business, and efforts to minimize the impact of parking on the surrounding neighborhood. Such plan shall be developed in consultation with the city manager and the chief of police, and may include, but shall not be limited to, the following. A, providing ushers to expedite drop-off pickup activity and or assist at pedestrian crosswalks. B, eliminating drop-off pickup areas on Rehoboth Avenue in front of the site. C, providing at the applicant's cost an appropriate number of officers of the Rehoboth Beach Police Department to assist in traffic management before and after theater productions. D, through the use of print and other media, applicants shall, 1, direct patrons to alternate means of access, including transit, walking, cycling, and ride-sharing services, and 2, direct patrons using private vehicles to carpool and park only in commercially zoned areas and city parking lots.
And then to that, we would add D, alternate D as a three, three eyes dot.
Exactly, without repeating any redundancies from 1 and 2.
Okay, Mr. Bryan?
Yes, would you consider adding an additional phrase or so to that that provides that in the event that the applicant shall have the flexibility to contract with a third-party provider of these traffic mitigation services in the event that the city no longer provides those services? Now, I understand it's discretionary. It's not a shall, it's a may. But I think they should have that opportunity if that type of mitigation, traffic mitigation, is no longer available. Let's say the city decides they just don't want to do that anymore. They have other priorities. And that's just all my only suggestion.
Okay. So sorry, I want to reset here for a minute. I thought the vice chair's proposal was to discuss alternate D alone. And then I think we had a suggestion to move to B. I'm reading alternate D as something the applicant must do. Well, it's something the applicant is already doing, and we want them to continue to do, and it's a requirement, a shall do. And I don't think it's necessarily part of something else that they may or may not do. So I'm not seeing the fit with B.
I think part of the confusion might be that people may not be realizing that D, as Mr. Bryan says, it is not discretionary. It has to happen. But I think the disconnect is that people aren't realizing that you can choose to go with D, and then A, B, and C are still available as additional measures. It doesn't have to be that D has to slide into one of the other alternatives. Is that correct, Vice Chair?
Yeah, that's the structure.
Okay, so I think either one of two things. Either we move on from D and come back to it, or we deal with D now to decide whether it's a good or a bad, and we slot it in to wherever needed. Is that better for everybody?
Sure.
Yeah, thanks,
Hold it now.
Okay, I feel better now. So Mr. Patterson, should we just continue with D, and then A, B, and C we can handle in the order that you wanted to handle them originally?
Yeah, I completely understand Mr. Weber's proposal regarding the ultimate structure of this condition 19. But just for simplicity, let's see, are there any objections to the concepts in D and that they are mandatory?
Anyone? So it sounds like everybody supports them. There's no objections that they're important, clear spaces doing them, and they should continue in the future. They're mandatory. So we do have a paragraph of mandatory condition language for whatever option we end up with.
Okay.
Wonderful.
So that's the easy one. Now to C. So C is the most prescriptive, right? It's mandatory and it's specific. And I understand Mr. Weber's concern about it. And let me just make the pitch. This is my pitch. This was mine initially. And the idea there for me is we do have very substantial public comment, and to the effect that the vast majority of persons traveling to this site will go by car, and they will prefer to park in the residential neighborhoods where at night parking in the summer is free. and it's not free on the Rehoboth Avenue and in the city main lot. So this new site for the theater contrasts with their existing location, where the nearest unmetered parking is much further away. City Hall main lot is much closer. And the applicant traffic study doesn't address this, in my view. And so the concern remains that the nighttime performances will attract a lot of people in vehicles in the residential neighborhoods hunting for that free parking, and then putting hundreds of pedestrians into the streets after dark, where there are no sidewalks, there are no marked crosswalks, there are no traffic signals, and the main streets have unpaved shoulders. So I do think it's unsafe to have such an intensive use in this location with so many people walking in the middle of the street to and from these events. And that the best solution I can think of is that these short-term contracts, just for one summer at a time and just for weekend nights when the use is most intense, is a good solution. That's my pitch.
Okay, and you did a great job. Does anyone want to react to that? Mr. Kaufman?
Well, two things. First, whenever we get these conditions, it should be read into the record first before we discuss it specifically, just like we've done in the last two. So I think that should happen. Why don't you do that, Brian? And then I do have a reaction to your point.
You're absolutely right. And
Brian, I can, if you want other people to do some of the reading, just ask. I'm sure someone will be happy to read it.
I will volunteer if you're looking for readers.
Okay.
Okay, I'll do one more for now. So this alternate C we're talking about says, recognizing that the intensity of use proposed for the site may have the potential to create risks of severe impacts, especially at times of peak seasonal traffic congestion, to the traffic on the city's primary vehicular route of ingress and egress, to pedestrian and bicyclist safety on streets surrounding the site, and to traffic and parking in the surrounding residential neighborhoods. No certificate of occupancy shall be issued by the city until the applicant has submitted license agreements or equivalent contractual commitments to secure 80 parking spaces with direct access to Rehoboth Avenue or to sidewalks leading to Rehoboth Avenue for the exclusive use of the applicant from 5 p.m. until midnight on Fridays, Saturdays, and Sundays from May 1st through October 31st of that year. And no performances or other events involving more than 100 spectators and or participants shall be conducted if the applicant has not by that date submitted such agreements to secure such parking spaces for such period of that year.
Okay, so now my comment. So I want to thank Brian for this and for all the others that he's done. I think it's a tremendous amount of work. Appreciate it. I oppose this condition for a couple of reasons. First of all, I don't believe it's enforceable because you can't require an applicant to have a condition that they can't perform. And one of the reasons they can't perform it is that owners of private lots have insurance and other liability issues that they would have to address. And for them to go into an agreement like this, they have to add clear space as a insured on their insurance. So I don't think that it's enforceable. And even though we have a section here that says, if one of these is found not to be enforceable or constitutional, the rest of the resolution would stand. I don't think that we can ask that, or we can put kind of a condition on an applicant when I don't believe there is the ability to actually bring it to bear. I'm not saying that it shouldn't be laudable. I think we can ask that that they have the flexibility to try and do it, but I don't. It should be aspirational. It should not be a strict condition. That's my comment.
Thank you, Mr. Kaufman. Mr. Strange?
Yes, I'll agree with Brian and disagree with Stephen. This is a dilemma brought about by the applicant's own design. Their original design accommodated parking, although quite frankly, that original design in every other aspect really wasn't that great. This particular design is better from the standpoint of the local residents in terms of being two physically separate structures that are further away from the northern border of the residential area. But it creates a larger problem. Essentially, you're trying to put 2 pounds of peanut butter into a 1 pound jar and it doesn't fit. And it oozes out all over the place. So the dilemma that the applicant has was caused by their submittal in this methodology, which eliminated a whole bunch of other hurdles that they need to apply for. So because it's a dilemma created by the applicant, I think it's absolutely within our obligation to the rest of the city to apply requirements that help ease the burden that the city is going to have result in this facility being constructed. Now, one of the comments that was made previously by a former board member who's no longer on the PC with regard to parking, and said, well, you know, parking's always been a problem, and therefore why should we burden these people very specifically? Well, that's true. Parking has been a problem, and I know of it personally since 1977. The only difference is over time, that parking, the duration of the parking problem has gotten more intense and lasts longer. And that's a reality. That's what's happening in the city. However, the contribution of this particular facility contributing to the parking problem would have been mitigated with their original design. Their original design, however, had other negatives that would have affected the community specifically, very locally. However, they wouldn't have to deal with this. So I think since they brought it on themselves by opting for this design and this philosophy and this approach, I think it's totally well within the authority of the city to protect the rest of the residents with regard to this. And you don't get a free pass. Thank you.
Thank you, Mr. Strange. Anyone else? Mr. Covington, please.
Yes, to Mr. Strange's point, the original drawing did have underground parking, and they took it out because they consider that to be a safety issue with a ramp, people pulling into the theater and pulling out and going up the ramp. And so they did take it out because of that. And I think they tried to include parking, but it just didn't work out from a safety point. And also, I agree with Mr. Kaufman that to require this, I don't think is enforceable, but also I think that it's almost impossible for them to enter into contracts with local people, secure parking spaces during the season. So I'm totally opposed to it.
Okay, thank you, Mr. Covington. Does anyone else have something to say? How do people feel about having a straw vote on this item? I think it would be wise.
So, Chair?
Yes.
I make a motion to include alternate C in the draft resolution, and so that if the motion fails, it will not be included.
Okay, you heard the motion. Is there a second?
Second.
Okay, second by Mr. Strange. Thank you so much. So the motion is to include alternate C in the draft resolution. And all in favor of including alternate C, please vote. So we have Mr. Patterson and Mr. Strange. Okay. All opposed? We have Mr. Bryan, Mr. Kaufman, Mr. Weber, Mr. Covington, and abstentions. That would be the chair and Ms. Lucero. Thank you so much. So we are not including mandatory parking under this provision C.
Thank you. So now for alternate A and B, per Mr. Kaufman's suggestion, I can go ahead and I've already read B, and I can go ahead and read A, but I suggest that we basically have a discussion about choosing between them. And then we can do a straw poll. So A starts off with the same verbiage for the first several lines. Recognizing that the intensity of use proposed for the site may have the potential to create risks of severe impacts, especially at times of peak seasonal traffic congestion to the city on the city's primary vehicular route of ingress and egress, to pedestrian and bicyclist safety on streets surrounding the site, and to traffic and parking in the surrounding residential neighborhoods. No certificate of occupancy shall be issued by the city until the applicant has entered into a traffic and parking mitigation agreement with the city, requiring the applicant, one, to implement effective traffic and parking mitigation measures to prevent the impedance of traffic in either direction on Rehoboth Avenue between 5th Street and the Circle. Two, to provide for safe pedestrian access to and egress from the site. Three, to protect against pedestrian traffic conflict. And four, to minimize traffic and parking impacts on the nearby properties and neighborhoods to the north and south. Which measures shall include all measures determined by the city manager or the chief of police to be necessary or appropriate. And which measures may include, among other things, during the times when more than 65 persons are expected to attend and or participate in events at the site, or as determined by the city manager or the chief of police. A, providing ushers to expedite drop-off, pickup activity, and or assist at pedestrian crosswalks. B, drop-off pickup areas on Rehoboth Avenue in front of the site. C, providing at the applicant's cost an appropriate number of officers of the Rehoboth Beach Police Department to assist in traffic management before and after productions. D, through the use of print and other media, applicant shall, one, direct patrons to alternate means of access, including transit, walking, rideshare services, and two, direct patrons using private vehicles to carpool and park only in vertical zoned areas and city parking lots. And E, securing by short-term agreements with commercial property owners or the city no less than 80 parking spaces with direct access to Rehoboth Avenue or to sidewalks leading to Rehoboth Avenue for the exclusive use of the applicants from 5 p.m. until midnight on Friday, Saturday, Sunday, from May 1 through October 31. So, to recap, the main differences between alternate A and alternate B. Well, the points in common are the list is indicative, not mandatory. They both seek to put some responsibility on the applicant to help address the impacts in some way. And then the points of difference are A requires an actual agreement. It's linked to the certificate of occupancy. It's more prescriptive about what the agreement must cover. And in terms of the indicative list, it has this last point about the may be required to secure commercial or short-term parking for their use. I think those are.
Okay, Mr. Mandela's request to speak.
I just had a question for the vice chair. If alternate D has already been voted to be included, does that then allow for subsection D in alternative A and B to be removed? I think those are repetitive, right?
I agree. I think D in both alternates is now redundant.
Wonderful, thank you. So this is a pretty juicy topic. I think folks will have thoughts about it. Does anyone want to share their thoughts, or they're getting their thoughts together? Okay, Mr. Weber and then Mr. Kaufman.
I wanted to ask for some clarification on A, as to whether the, A through E are mandatory, or they're back to the may or shall or should. It says that the applicant has to enter a traffic and parking mitigation agreement with the city, which may include these items. Under that scenario, who determines what items are included and what aren't?
Yeah, so my intent there, it is a may. The list of items like the ushers and the using the police department and the parking, they're all illustrative. I think by including illustrative, it does empower the city manager and the chief of police to negotiate up rather than, or negotiate down rather than up from nothing. But yeah, it is really left in the discretion of the city manager and the chief. What do they think they need?
Mr. Kaufman, were you next, or?
Yeah, I think I was.
Okay.
Were you done? Were you done, Lee? Did you have anything else?
I'm done, thanks.
I prefer B here. And although they're pretty close in a lot of ways, but I would like to add Mr. Bryant, his suggestion in terms of the alternative. And I wonder if he wouldn't mind repeating it. You need to unmute, Mike. You need to unmute. Great.
One more time. You're
Now
still
you're muted
still
again.
muted.
Now how are we
There you
now?
go. Good.
Okay. My thought was to provide the alternative so that a third-party vendor or third-party service that provides this type of traffic management could step in if the city no longer decides to provide this service.
Thank you. So I would add that. I think it's a very good suggestion, and so I would support B.
So Michael, are you suggesting that, for example, if the city doesn't have the resources to provide a police officer in front of the theater, that they could contract to a third party to do that?
Yes, sir.
Okay. I think that's a good idea as well.
Okay. Doesn't appear there's any opposition to that idea, so we'll include that.
So yeah, my pitch is I do prefer A because I do worry that if it's just a plan, it's the applicant's plan, and the applicant's plan doesn't necessarily have any ability to be enforced. It doesn't have sort of the same status of private law that an agreement with the city has. And therefore, I do think the importance of these issues is such that I would favor making it as tight as we can, while still leaving it to the city manager and the chief of police to negotiate what they need.
So thank you, Mr. Patterson. I think we have some PC members who have experience with traffic and parking mitigation agreements. And I don't want to call on anybody if you don't want to say anything, but I thought maybe Mr. Weber or Mr. Kaufman might want to talk to us a little bit about that. Mr. Weber, go ahead.
And I don't know if I'll talk about that specifically, but I mean, I have confidence in the chief of police and the city administration and the applicant that if there are issues, that they'll address them. I mean, the applicant is running a business that they want to be successful. And if there's issues with parking or there's issues with traffic or getting in or out, they're going to have to resolve those, or it's going to be to the detriment of their business. I think that the same. I have confidence in the police department and the city manager that if there's issues, that they'll get addressed. I'm not suggesting that the applicant get a free pass, as has been mentioned, but I'm in favor of alternate B, because it does require them to do a plan that's subject to the approval of the city manager. So it kind of forces them to work together with the city to come up with a plan. And, this, I maybe could formulate this into a question for the chief of police. If there is a continued issue at a particular intersection or on a particular block of a street, I'm assuming that the department and the city manager have the ability to come in and address that issue and resolve it. I don't think we should go into this thinking that this is the end of the discussion and that all these terrible things are going to happen and nobody's going to be able to do anything about them. I don't think that's how it works in a practical sense. I mean, we've through the approval of condition 20, we've set up a process for all the stakeholders to get together and discuss issues and come up with resolutions. But I think that the motivation of all parties is aligned to make sure that any particular issues that come up get resolved.
If I may, Chairman, to answer Mr. Weber's question, is yes, and that's exactly how we've done it in the past. If we've identified by just what we have observed, or if neighbors have complained or had some concerns, that's exactly what we do. We try to get the parties together, or we come up with some type of solution to the problem. And we've actually had to do that to other businesses in town. So yes, that's our normal course of practice.
Okay, Mr. Kaufman. Thank you, Chief.
Thank you, Jeff. Yeah, I experience with these third-party traffic mitigation agreements. Generally, they're done by the traffic consulting firms in the country. For example, the Traffic Group, which did the traffic analysis for ClearSpace, manages a number of these all over the country. So in the event that the city either doesn't have the resources or the manpower to do it, that's why I thought Mr. Bryant's suggestion was a very good one. These companies do have the ability to do it. Not only that, they also advertise it as one of their roles as traffic. So I think it's a good idea to have that alternative if for whatever reason the city is not able or can't perform, in that role.
An observation I have, A has the word traffic and parking mitigation agreement with the city requiring the applicant. B says traffic and parking mitigation plan subject to the reasonable approval by the city manager. Those are different words that I think describe the same course of action. And further, if you look at in A, the enumerated list, 1, 2, 3, and 4, those things are almost repeated in B verbatim. So I'm wondering if we're, with a little bit of formatting and being clear about plan versus agreement, and whether the city manager actually approves it or people work in close cooperation with the police force and them, if we're almost converging on an alternative that blends these two concepts together. What do folks think about that? Mr. Weber?
I agree with you. I mean, my sense is that the only material difference between the two conditions is in alternate A, E, with it, once again, the requirement to secure short-term parking agreements with commercial property owners. It's the same. It may not be as definitive as it was in C, but it's still there, and that's the primary difference between the two conditions.
Okay, I mean, stylistically, I sort of like the way alternate A first paragraph enumerates 1 through 4. But that's just for clarity. And then I guess following on Mr. Weber's comment, I mean, I think the intention of E about the short-term parking places, I mean, we've eliminated that as a mandatory condition. But do we want to empower the police and the city manager that should complaints and problems be overwhelming, they would have another tool to not require, but to discuss with the applicant? Would that be a horrible thing if it was just suggested as a tool? Mr. Covington, please.
I think that would be. I think, we don't know who the chief of police is going to be or the city manager is going to be, down the road. So I think that we get back to the same issue before. If this is in there, even as a suggestion, it's an ammunition for others to come and say, well, they haven't in full faith tried to get these number of parking spaces. And it's a subjective determination whether or not they have or have not. And I think by putting it in there, it just clouds the waters and makes things fuzzy and difficult and creates confusion. So I would be in favor of either alternative A with deletion of letter E, or going with alternative B.
So let me try a trial. Well, go ahead. You first, Mr. Weber.
I just have one quick comment. In alternate A, it talks about this being a requirement before the issuance of the certificate of occupancy. That's right. B, it talks about before opening business. I don't.
That's the key.
I don't think we should hold their certificate of occupancy, as it's often a trigger on financing and various things that they should be able to get a certificate of occupancy, but have to comply prior to opening for business.
So can anyone else speak to the certificate of occupancy? Mr. Bryan?
I'd like to echo Lee Weber's comments. I think he's exactly right.
I agree as well.
Okay, so do we need to straw vote on this one, or I think we may have agreement about the certificate of occupancy is not something we want to hold to? Did anyone want to speak opposing that? Mr. Strange?
Yeah, I'm really conflicted on this because there's a series of a priori assumptions that people are making that I think are inappropriate. The original traffic study that was submitted that we got in August, we got 24 hours in advance of the original meeting. And we didn't have much time to really examine it. But one of the difficulties with that traffic study was done completely wrong. And as Stephen pointed out, that this was a major consulting firm, and I'm surprised that they did it completely wrong. They did it based on average annual daily volumes, which is not what you do. You do it based on peak, which is a requirement, which is what LDOT requirement is. And it's a requirement of every textbook utilization when you do traffic study. The other thing was they focused on cars and not trips. Trips is what you need to focus on. Cars are just one of the many modes that you use, so that the underlying assumption that of what the impact is going to be was severely minimized in that study versus what the reality is in terms of similarly situated institutions in close proximity to major arterials. In our case, we have the roundabout, and this facility will be 100 feet from the roundabout. And it's on the major point of egress and access to the city. And the modalities that people are going to be using in this 273-seat theater, the way in which the traffic study was done did not take into account the totality of trips that you actually have to do per the ITE manual, which is mystifying to me as having knowledge of this area. So the result is that we're making assumptions based on a project where the analysis was insufficient and was quite frankly lacking significantly. The number of trips will be quite significant. And depending on, and it's based on the full build out of the facility, not what they currently do, not what their current loading at their current theater. It's what the ultimate loading will be in the future. And so you have to do it on the maximum, not the minimum. On that criteria, I think it's absolutely essential that the mitigation agreement be examined and looked at before a certificate of occupancy is issued, because otherwise you're letting the horse out and then you're closing the barn door, and that's too late. There is a very real risk of the egress and access to Rehoboth Beach around the roundabout with this facility where it's located, that in fact, the area will go into saturation and quite frankly collapse from the standpoint of traffic. That is very real, and that's based on the numbers. So I don't think we can take a very, I don't want to say blasé, but a very passive attitude related to that. We have to protect all the residents of the city. It goes far beyond just the individuals that are locally impacted by parking. The entire city will be impacted if that intersection goes into saturation multiple times. And it's particularly important from the standpoint of our charge in protecting the city against panic and safety. So I think you do have to go the extra distance, and it may be difficult, it may affect their financing, et cetera, but that's moral hazard. That's something they know. Thank you.
Thank you, Mr. Strange. So I think well, go ahead, Mr. Kaufman.
I thank Michael for his analysis, but the reason the traffic group, what it did is peak hour trips are used for the morning and evening commute. Of option of this theater will not affect either of the peak hours. It doesn't start its operation until after the evening peak, and obviously it doesn't affect the morning peak. And so I think their methodology was fine in this case. Normally you would go with peak hours for the morning and evening commute, but this doesn't. This particular use does not impact either of those volumes. What I'd like to do is I'd like to make a motion in support of option B with the addition of Mike Bryant's alternative for a third-party vendor in the event the city is unable to carry out the obligations of the agreement.
Thank you, Mr. Kaufman. It looks like we have a second from Mr. Covington. Does anyone want to say anything more about this motion? Okay, so let's have a vote. So the motion is for us to adopt.
Hey, Jeff?
Oh, Lee, sorry.
How are we addressing the certificate of occupancy issue?
Well, before Mr. Kaufman spoke, I was going to repeal what I said earlier, that we don't need to have a vote, and I was going to suggest a straw vote on that matter. But since the certificate of occupancy is in A, would we like to do that? I guess is what I should say.
No, never mind.
Okay.
Yeah, I think B
is
prior to opening. B says prior to me for business, not before.
Never mind.
Yeah.
Okay, so let's continue. Mr. Patterson, please.
Yeah, just to add a second for what Mike said, I do think that B is not sufficiently robust for the critical impact that we should and can foresee to the traffic.
And Mr. Patterson, would you like to amend the motion to add something from A to do that, or should we proceed with the vote?
Well, I think I'll move to amend the motion to revise alternate B look like A. There's no point in that. Why don't we just vote on B? I think and
Okay, very good. Thank you. Okay, so the motion is to adopt a B as amended by Mr. Bryan.
Oh, wait, no, he didn't he back out of that? Oh, I'm sorry. Okay, you're right. I'm sorry.
Mr. Bryan, not Mr. Patterson. Yeah.
Right.
Are we good?
Okay, we're good.
Okay, I'll try one more time. I'm sorry, I contributed a lot to this confusion. So one more time. So the motion is for the Planning Commission to adopt alternative B with the clarification by Mr. Bryan that a third-party vendor could also be used. So all in favor of this motion, please say aye. So we have Mr. Covington, Mr. Bryan, Mr. Kaufman, Mr. Weber, and myself. That's 5. All opposed? We have Mr. Patterson, Ms. Lucier, and Mr. Strange opposed, and then no abstentions if I counted right. Okay, super, thank you. So alternative B it is.
And is the Planning Commission in agreement that subsection D of alternative B, because of the redundancy we spoke about earlier, is not part of subsection or alternative B anymore, because it's covered by alternative D?
Right.
Yes.
I think that's right.
Okay, great. Everybody agrees to that. Okay, so this brings us to an interesting juncture. It is 12:33. We do need to take a 30-minute break for the city staff. We could start another section, or we could take the break now and come back and start anew on another section. Is there anything left to do on this section though, before we say that? Traffic and parking. Have we addressed everything that we plan to address?
I think we have.
Yes.
Right. Well, I think this is a clean stopping area. If everybody's okay, why don't we reconvene at say 1:05?
Sounds fine.
Okay, thanks everybody.
Thank you.
Thank you.
whenever the live stream is good, we can start again.
You're good.
Okay, welcome back, everybody. We're continuing now with the special meeting for the continuation of the public hearings for the site plan review applications for Clear Space and Rehoboth Spotlight. We've been reminded by Brent McCormick at the city that when we're not speaking, we should mute our microphones to reduce the background noise. So that's helpful for everybody. I wanted to thank the vice chair, Mr. Patterson, for the heroic job he did in leading us through the section that we just completed on parking and traffic, and all the preparation and explaining he did so that we could sort through the different alternatives. It was hugely helpful, and I think very easy for everyone to follow along. So I'm very pleased with the progress, and we're ready to continue. So also, Mr. Patterson, do you think we can let Chief Banks go? I don't think we're going to have other questions for him. So I'd like to not take up more of his time than we need. Would you agree?
Yes, only with the caveat that the issues on my list and in the draft, I think we don't need the chief. But maybe we haven't necessarily asked other members, do they have other things they want to take up that are not addressed in the draft? And the things to come, of course, relate to square footage, the use, educational and cafe question, those use things, and then back to the noise and the lighting. But if there are other issues that members have, that would be the only thing.
So that's a good point. So why don't we, Chief Banks, if you're able to stay and listen, then I think we're fine for now. But we expect, unless something new comes up, that we're in good shape for now. So I think it's fine if he stays on. Thank you. So are you ready to resume, Brian?
I think so.
Okay.
So the next subject I wanted to cover is what I called, the heading is design clarifications. And there's a condition 18 on page 6, which I'll read in a moment, with 2 alternates. But there's also a finding on this issue that I've added on page 4 that I'll read in a moment. And just to summarize, design clarifications is sort of my polite way of saying that I think ClearSpace has some problems in the drawings they submitted in their application, which would have to be modified, as specifically as pertains to the floor area calculated under the zoning code. So I drafted finding number 3 to acknowledge this, and if we agree on solutions, then the finding indicates that. And then the conditions, the alternate 2 is just a reformatted and revised version of what I circulated last time. Alternate 1 reflects Mr. Weber's good suggestion to leave more flexibility for the applicant's design team, since we don't really know the full extent of the issues and potential solutions in the design. So, so let me read them now, and then I can give a little bit of a framing. The finding is number 3, the third finding on page 4. We would find that errors and omissions in the submitted drawings preclude a finding as to the accuracy of the applicant's calculation of gross floor area, zoning square footage, specified on sheet A002, and said errors and omissions are made immaterial by the adoption of condition which I think would be condition 18. So that's the finding. It would only apply to clear space. And then the two alternates for the conditions on page 6, alternate 1, prior to the issuance of a building permit, applicant shall revise and resubmit the permit drawings to the chief building inspector, and possibly in brackets I've got and the planning commission, to include sufficient detail demonstrating compliance with the gross floor area requirements of the zoning code, and making CAD drawings available to the building inspector to verify compliance. That's alternate 1. Alternate 2 is a little more prescriptive. Prior to the issuance of a building permit, applicant shall revise and resubmit the permit drawings to the chief building inspector, bracketed, and the planning commission, to demonstrate that A, exterior dimensions on sheet C2 and any other affected sheets are reduced so that the standard square footage and the zoning square footage on the first orchestra floor do not exceed those specified on sheet A2. B, no interior ceiling height shall be taller than 12 feet in the areas identified as the first orchestra floor lobby, back of the house, loading, crossover, and the second floor balcony seating, or any other rooms or areas with the exception of the 2,553 square feet of stage, orchestra, elevator, and staircase area that have been included by the applicant in its gross floor area zoning square footage calculations for the second floor as shown on sheet A2. So you can see the second alternate gets into a little more, well, a lot more detail of what I think are the problems, which I can summarize. And if anyone agrees these are problems, then we could talk about whether finding number 3 is appropriate and whether the solutions work. A threshold question that has been raised by some fellow members and some public comments and comments by the applicant is, why are we looking at the floor area of the building when the building inspector already gave preliminary approval? I think we've spoken before about the degree of deference to be accorded to the building inspector's preliminary approval at different steps in our process. And here we are at the end of our process. I think the applicants themselves have settled any doubt, at least in my mind, that we are obliged to take a hard look at this when, in response to my questions in the public hearing on January 29th, Mr. Paulson stated that in consultation with the building inspector last year, their architects went back and did put in lower ceilings to bring them within the zoning code. And Mr. Paulson gave the lobby as an example, where he said they were hoping to have exposed ceiling, but gave that up to meet the 12-foot limit. And he went on to acknowledge their architect would be happy to go back and make whatever other changes are necessary to areas that exceed 12-foot ceilings. And then Mr. Paulson followed up in writing in the clarifications document received on February 22nd, and in which he stated, quote, "The ceiling height in the lobby and other spaces identified have been modified to 12 feet as identified in drawings and emails between Sue Haynes and Don Molina in June 2020, end quote. So Sue Haynes is part of the architect team for the applicant. But remember, check your drawings. The drawings submitted to us as relevant to the floor area are all dated before June 2020. For example, I refer to sheet A2 dated May 29, 2020, and sheets C2, A101, A401, and A402, all dated April 17, 2020. And I could not find any revisions to any of these sheets or anything else relevant to floor area subsequent to those dates. So by the applicant's own admission, what is in front of us in the application, I now realize, is incorrect and not compliant. So whatever the building inspector gave his preliminary approval to has not been submitted to us. So we don't know what the building inspector found to be compliant and what changes the architect has made. And section 236-32 requires that if the site plan must be revised, the revised site plan shall be resubmitted by the applicant for preliminary approval of the building inspector. And then, according to 236-30, the revised site plan should be reviewed by us for formal approval. But the applicant, for reasons that I do not understand and don't know, chose not to resubmit their revised drawings, which they now say they made. So where does that leave us? I think one potential solution, although I'm not sure it's within our power, but for discussion, is this finding where we would acknowledge there are errors and omissions in the drawings that preclude us from making a finding as to the accuracy of the gross floor area specified in the application itself on sheet A2. But perhaps the errors and omissions can be made immaterial by adoption of these conditions. So I think, the issue in my mind are of two kinds, but there's a broader issue as well for discussion. Do we have the power to move forward, even if we adopt this finding and the condition that the drawings be revised and resubmitted either to just the building inspector or to both the building inspector and us? Is that proper for us to do now? Or would it be better to, frankly, deny the application and give the applicant a chance to submit a new application with the complete and accurate and current drawings?
Thank you, Mr. Patterson. You set that up very nicely. Shall we have some discussion? Anybody have a question? Ms. Lucier? Still muted. Okay, there you go.
Did I understand correctly, Brian, that the applicant is saying they now have the correct correct drawings? I mean, this puts us back to square one if we don't have, and if they do, could we have them?
So the direct quote from what they wrote to us on February 22nd is, quote, "The ceiling height in the lobby and other spaces identified have been modified to 12 feet as identified in drawings and emails between Sue Haynes and Dan Molina in June 2020, close quote." So they may have modified some things or everything in June 2020. I don't know. They didn't, articulate exactly which spaces they're referring to. And yet they didn't submit them to us.
They did not. Can they be asked that question now? Is that possible?
Well, we can go to the applicant. I'd rather have a little bit more discussion though before we do that and exhaust some of the internal resources. So, Mr. Mandelis, do you want to say something?
I was going to offer just that you go to some of the internal resources. For example, the building inspector is on, and I think he can probably give some more flavor to what has occurred in the plan process.
Right. And then Mr. Weber, you wanted to say something? You're muted.
I would, but I'll wait to hear what the building inspector has to say first.
Okay, so Mr. Janis, are you able to join us? Let's bring in Mr. Janis.
Yes, I am here, but I'm not on video.
Oh, okay. Well, that's no problem. Did you hear Mr. Patterson's introduction to this question?
I did. If you could just repeat the question for me one more time.
Sure, I can summarize, but I'll ask Mr. Patterson as well. So in terms of the chain of communications and the sequence of drawings, and of course, everything that we've heard in public comments in other areas, there may be discrepancies in some areas about the gross floor area. We don't know exactly where or the magnitude. We don't have any reason to believe it's a huge discrepancy. And I don't think we have any reason to believe it's something that's not easily correctable in a final set of detailed documents that would make the measurements possible. And of course, we've had a change in the building inspector. So,
right.
We don't know to what extent email records and some of this may be available, clear, or you may even be in the loop of this. But, we would like to be as positive as we can. Well, the building must meet the zoning code, so there's no question about it. Do we have what we need, or are we expecting one more iteration?
So just for points of clarity, moving forward, knowing that we have had revisions to certain pages of that set, I would request from the applicant a full collaborated set that is not piecemeal. So all pages are together in one set. So therefore, we don't have the opportunity of any mistakes being made for foundation sizes or anything like that. So a full set of documents would be on site for the entire construction.
Wonderful. And anything else you'd like to add?
No, but I should add that I do have the emails and the agreements between Sue and the former building inspector.
Mm-hmm.
So I am aware of the, I guess, agreements that were made between the two parties.
Mm-hmm.
They do seem sound to me, but there again, I would like to verify, all drawing sets before we publish this thing for permit.
Wonderful. Thank you so much. That's very clear. If you would stand by, what I'd like to do is have more PC discussion, and then we'll come back to you if there are more items to discuss.
Absolutely,
okay.
Sir, no problem.
Thank you. Mr. Strange.
Yes, with regard to Brian's comments, although I believe this application should not be approved, period. Having said that, I think with regard to the floor area ratio issues that have come up in the ceiling height, although these patterns of behavior, floor area ratio versus ceiling height, exist in many other jurisdictions, there is absolutely no scientific, rational, urban planning, architectural logic as to why the ceiling should be a particular height and then you double the floor area ratio by 2 or any other number. It's completely irrelevant. And what I would recommend is that we go with the drawings that we currently have, continue the process. But I would also recommend, as a principle, to the applicant is that they should go to the Board of Adjustment at a future time, because I don't think the interior architecture of the facility, if it meets all the external requirements, exterior requirements, should have to modify ceiling heights due to some arbitrary and what I think is capricious floor area ratio versus ceiling height that we have. The building would be better designed as it was originally done, strictly related to the height, because it's more beneficial in the interior spaces. Particularly in these times of COVID, it actually makes much more sense to have a higher ceiling height. So it's food for thought. Thank you.
Thank you, Mr. Strange. That's a thought-provoking comment. I hadn't expected that, but thank you for making that. Ms. Lucier and then Mr. Kaufman.
Yeah, I just have a question. Since the record is closed, how can we take in, and we're refusing other, well, anyway, the record's closed. How can we bring in any more any changes from them. Is that permissible?
Well, at this point in time, I don't think we're bringing in any new information. Mr. Patterson is referencing the sets of documents that we have, and of course we're discussing that as to whether or not we need a remedy in our findings and conditions. So, I mean, we could get to the point where we need new information, but I don't think we're there quite yet in the discussion.
Yeah, I think just to add to that, Joyce,
yeah,
the thinking, the remedy would be they do have to revise and resubmit,
right.
either only to building inspector or to both them and us. I guess a legal question for the solicitor is, I mean, these are conditions, but can you have a condition that puts the entire legality of the project subject to the satisfaction of that condition?
Yeah, that's what I'm asking. Can we, if we're dealing, and I don't know if we're dealing with a building that's not that doesn't work with the code. Anyway, that's a question for the lawyer. I don't know the answer to that.
Good. If I could ask PC members to hold their questions for a moment. Mr. Mandelis wants to say something first.
Sure. So my understanding with the plans is that before the plans were submitted to the Planning Commission, they were deemed zoning compliant by the building official's office. The chronology, as I understand it, is that they submitted, ClearSpace submitted the large set of plans. Mr. Molina did some review, and Mr. Janis, listen closely, so if I say something incorrect, I'd like you to correct it. But my understanding is that Mr. Molina reviewed the plans and noticed certain things that were not in compliance with the zoning code, such as certain ceiling heights and gross floor area. Through a series of discussions and emails, they, between ClearSpace, the ClearSpace designer and Mr. Molina, they identified these problems, worked them out through what is called in their line of work addendums. So they can be addendums that are attached to the back of the drawings. So those agreements are all in the emails, but never got attached to this set of drawings yet. That Mr. Janis was referring to, when the project goes forward, should it go forward, rather than having an addendum, he's going to ask them to give a full set of new plans with every sheet corrected as it should be. But my understanding is that at least in the building inspector's office, these issues had all been worked out before it came to the Planning Commission, but didn't all get inserted into the drawing. So I think that the condition that's been proposed is appropriate as a kind of, boot and suspenders, make sure that that follow through happens in the building official's office. So I think it's an appropriate condition that you can attach. I don't know that it needs to come back to the Planning Commission for those interior building items. Matt, is there anything, or Mr. Janis, is there anything that I may have misspoke?
Thank you, Mr. Mendoza. I agree with your timeline. The revisions were requested before the plans hit the Planning Commission. So we are, again, I believe we're in agreement with the plans. Nothing was changed once it hit the commission. And as Mr. Mandela stated, I personally, and I'm sure the city would appreciate a full set of plans without pages, that could possibly go unattached to these, to the sets that actually reside on the construction site during inspections, so that we have a good, concise, clear set of plans that we're building to, and that opportunity for errors in the either downsizing, if necessary, for the building, or whatever may occur with the plans are true to the site and true to the accepted and approved plans.
Okay, thank you, Mr. Janis and Mr. Mandelis. So we have queued up Mr. Kaufman, Mr. Weber, and Mr. Covington. Mr. Kaufman, can you go?
Well, I'd like Lee and Mr. Covington to go before me.
Oh,
if you don't mind.
wonderful. Okay, Mr. Weber.
A couple of things. One, and this is a question for Matt. I think it's fairly typical that buildings that are submitted for zoning approval, once they get into the building code approval process, the building permit process, there's often very minor changes in the building to meet code, maybe a hallway width, handicap access clearance. It's typical that things get tweaked in the drawings. And I think this is one of those type of items. It appears that it's a very de minimis amount of square footage, and that we certainly shouldn't hold up this proceeding because of a couple hundred square feet that can be resolved. And also the first condition, condition number 1 is that the site plan of the property shall be substantially in accordance with the drawings referenced. And I think certainly within a couple hundred square feet to be corrected can be deemed to be substantially in accordance with. So I don't see that there's any reason to do anything on this other than agree to a condition that it's resolved prior to the building permit being approved.
Wonderful. Thank you, Mr. Weber. Mr. Covington?
I was going to say the exact same thing, and I think that Mr. Janus articulated my concern going forward. I think we can proceed with this building permit or the site plan review, and then put a condition that the building be compliant.
Okay, thank you, Mr. Covington. Now, Mr. Kaufman?
Why don't you let Mr. Bryan go too?
Oh, Mr. Bryan, go ahead. Did you have something?
You're muted. You're muted, Mike.
Mr. Janus.
Okay now.
Mr. Janus?
Yes, sir.
Please just confirm for me and the assembled group that these addenda you've referenced were in fact delivered to the building inspector's office?
Yes, they were. Yes, sir.
Okay, so the building inspector knew about these addenda, having seen them, having discussed them and whatnot. So this is not new news. It's just sort of misplaced news. If that may not be a correct term either, not misplaced. It's just not.
Yeah, I don't know that I'd label. Pardon me.
It's just not attached to the plans.
Correct. Yeah, I wouldn't label them as misplaced, just corrected, if you will. As Mr. Weber states, changes happen all the time. My main concern with these addendum would be that should a foundation change or something like that of major size, that those changes, would be incorporated into the set. However, that's just an example, and these particular plans were submitted prior to any push towards the Planning Commission, and they were very minimal in size or in scale, and they were directly related to ceiling heights throughout the building.
Mr. Chair, I concur with Lee Weber and Mr. Covington. I think we should move forward.
Okay, thank you, Mr. Bryan. And Mr. Kaufman, back to you.
First, thanks everyone for going ahead of me. First, we have a finding of compliance by the building inspector. So that's the finding we have. And this reminds me of some of the comments I made when this was first remanded to us by the city commissioners. We've always had everything in the record before you reach a point of decision, as long as all the things that are necessary ultimately are done. So an condition you would need is a condition that says drawings need to be submitted to the building inspector to make sure that condition 1 is met. It should not come back to us. We don't review building plans per se. We rely on the experts that advise us. And the building inspector, as number 1, said it's in compliance. And number 2 said that they've received adjustments by the applicant to address the issues that were raised. And number 3, the building inspector has asked for a full set of plans prior to the issuance of a building permit. That's more than sufficient for us to proceed with this application, and this matter is basically settled in my mind. Thank you.
Okay, so have we heard from everybody? Back to you, Mr. Patterson, and you're muted right now.
Thanks. So yeah, just one or two reactions. I mean, I don't know who has looked at these plans or not, but I have. And it's not a de minimis issue. It's not a few hundred square feet. As Mr. Paulson himself conceded, the entire lobby was out of compliance. And in the drawings submitted to us, that's almost 1,000 square feet. Right? So in January at the hearing, I listed the areas that I found, and I have no idea whether the areas that I see discrepancies or omissions are the same as the areas that Mr. Molina found and that have been addressed in addenda, because none of it was submitted to us. But what I come up with is over 2,000 square of area that, according to the architect's diagram on sheet A2, were not counted twice as required by the zoning code. And I take Mr. Strange's point, the 12-foot rule, which, as I recall, was adopted with residential structures in mind to address the bulk and mass of residential structures, to keep the high ceilings from sort of avoiding the intent of the far limit of residences. Nevertheless, in their wisdom, the mayor and commissioners did not limit it to residential structures. This is the code we have and found to apply. So in addition to the lobby, which is about 1,000 square feet, and the second floor balcony area that has been estimated at about 350 square feet, there is an area identified as the first floor crossover, which is behind the stage on the first floor. And the drawing shows a ceiling of 14 feet, 8 inches. There is an area on the west side of the building behind the curved wall at the rear of the house, identified as IT and electrical. The crossover is more than 300 square feet. The area on the opposite side of the building is labeled IT, electrical, and storage. Looks to be 100 or so additional. And then the first floor loading area specified with a ceiling higher than 12 feet. That's another 200 square feet or so. And then the back of the house area on the first floor is probably or so square feet. So I easily get to over 2,000. And several of these areas, based on my limited experience in theater, are areas where a 12-foot ceiling might not be practical for the theater. To have a 12-foot limitation behind the stage where you are moving scenery and sets in and out, and at the loading area, et cetera. So I do think the design team has some work to do. I don't know whether that work is already done or not, but I do think it would be a corruption of the entire process of site plan review and public hearings for us to just leave it in the hands of the applicant and the building inspector, send it back to fix these issues that the applicant knew about and chose not to reveal to us through 8 months and 2 rounds of public hearings and an appeal. I think the entire public hearing process has been corrupted by that sort of original sin.
Sorry, unmuting. Thank you, Mr. Patterson. So Mr. Weber is raising his hand. Go ahead.
Yeah, I'd like to make a motion that we approve alternate 1 as written. The building inspector has confirmed the square footage of the building. There may be some issues. The applicant agreed to correct those issues. I think all the information out there that's Dates, the square footage, I think is merely hearsay. And I think it's fine that they go forward. They submit drawings with the building permit so that they can confirm with Mr. Janis that they do in fact meet the code on the square footage. I don't see any reason to stall the process for this.
Okay, so we have a motion to go forward with alternative 118, the additional design clarification.
I'll second.
Is there a second to that motion? Mr. Covington? Okay, there is a second. Shall we go to a vote, or is there anything else to be said? Mr. Patterson and then Mr. Bryan.
Well, I was going to move to amend the motion, or at least seek a clarification. Well, I think I know the answer, so let me move to amend the motion to include the bracketed language referring to resubmittal also to the Planning Commission.
Okay, we have Mr. Patterson's motion to amend the motion to include resubmission to the Planning Commission. Is there a second to that motion? I don't see any. So that, oh, go ahead. Joyce, you're muted again. Sorry, we'll wait for Miss Lucier. Go ahead, Joyce.
All right, I will second it, but can you tell me what we're voting on now? Exactly. We've had a break here.
Happy to do that.
Thank you.
Mr. Weber, I'll do it succinctly. Mr. Weber made a motion to adopt number 18, alternative 1.
Alternative, all right, that's all I need. Okay.
And you second that the Planning Commission would also get a set of these drawings.
Right, okay.
Okay.
Thank you.
So let's vote on the Mr. Patterson's motion. Mr. Covington, do you want to say something?
I do. If the amended motion saying that we get a set of these drawings, do we get a set? Do we then have to review those and also approve them with the building inspector, or are those just courtesy copies?
Yeah, the intent of my motion, and you're correct, the language isn't so clear as it should be, but the intent was that it would read, applicant shall revise and resubmit the permit drawings to the chief building inspector and the Planning Commission for approval to include sufficient detail, etc.
Thank you.
Okay, does everybody have the motion now? Any other questions? Okay, the amended motion that the applicant would revise and resubmit the diagrams to the building inspector and to the PC for approval.
Can I clarify?
Yes, Mr. Vandellis.
We're only voting if it's proposed amendment to the motion.
Right, we're only voting on that.
The bracketed Planning Commission language in the motion.
Thank you for the clarification. So I'll try one more time. So we're just deciding whether the plans come back to the Planning Commission for approval. Everybody good? Okay, thanks for, oh, Mr. Patterson?
And just as a matter of discussion, I do think that if we don't approve the amendment, we are running a real risk of being reversed again. Because, you know, if the building inspector finds them compliant and we can find them compliant, it should be, but if we choose not to look at them again, then there is a question whether we have done what the code requires us to do in terms of giving formal approval to the design as it has been preliminarily approved by the building inspector.
Okay, thank you for that clarification. Let's vote. Okay, so everybody who's in favor of the amendment that would require the plans to come back to the Planning Commission for approval. All in favor? Okay, Mr. Patterson, Mr. Strange, Miss Lucier. We have 3, 4. All against? We have Mr. Kaufman, Mr. Weber, Mr. Covington, Mr. Bryan, and the chair is going to abstain on this one. So the motion to bring the plans back to the Planning Commission has not passed. Okay, so let me pick up again. So, oh, go ahead, Mr. Patterson.
So on the, going back to Mr. Covington's good point about the wording, and would Mr. Weber accept or agree that the phrase "for approval" should be inserted after the reference to the chief building inspector? Or is this just a courtesy exercise?
I don't have a problem with that.
So that the alternate,
If you continue reading it, it says to include sufficient detail demonstrating compliance with the gross floor area requirement. That means, and in CAD drawings for the building inspector to verify compliance. I'm assuming that means approval.
okay, fair enough.
Okay. That's
Okay.
good.
All right. Okay, so Mr. Bryant, did we not go to you earlier? Did you have your hand up, or do I misremember the order right after Mr. Patterson? Did you want to say something?
No, sir. I'm fine. Thank
Okay,
you.
okay, good, okay. So now, oh, okay, Mr. Patterson.
So yeah, just so one thing I would say here is I think I will vote in favor of it only because I do think it is absolutely necessary to have a a viable, sustainable resolution at the end of the day. But I do have misgivings for sure, like Mr. Strange.
Okay.
Okay, so correct me if I'm wrong, but we are now going to vote in favor of the resolution not amended with what we just voted back down. Is that right? That the amendment,
Yes.
the amendment is to revision and resubmission to the chief building inspector to verify appliance, meaning giving his approval. Mr. Weber, do I have it right?
Yeah, I just, before I vote, I would just like to ask Mr. Mandelis his opinion on Mr. of the condition as it relates to the planning commission approving the drawings again.
So I think I heard you cut out for a moment, but I think your question was whether to Mr. Bryan or to Mr. Patterson's point, the plans would need to come back to the planning commission again.
Correct.
So I have a few thoughts on that. I'm reminded of, for example, the beach walk application. And the beach walk application, if you recall, it was a series of condominium units laid out on a plan. There were no interior drawings for that submittal. And those plans were proceeding through without any interior design. So I generally understand a site plan to be more about travel lanes, placement of buildings, entrances, exits, outside shading, those sorts of things, and less about the interior of the building. So I'll be honest that I think getting too much into the details of the interior of the building is the purview of the building official. A building official cannot issue a permit without confirming compliance with the zoning code, the building code, the fire code. So my view is that these plans would not need to come back to the planning commission for a final review for interior matters.
Okay, thank you.
Okay, that takes care of that question. I don't see any other hands. So why don't we proceed to the vote for this motion, which is that the applicant needs to revise and resubmit plans for verification by the building inspector. All in favor of that motion, please say aye.
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 So it looks like we have a unanimous vote.
Yay.
Okay, great. Hooray. All right. So that's kind of a sticky one. And thank you for your excellent recommendations and discussion on that. So, do you need a breath, Mr. Patterson, or shall we continue?
We can continue, I think. Another somewhat sticky one is what I call the use clarification. And so when we talked about this last time, Mr. Kaufman made a good suggestion that these issues, or some of them, can be addressed as findings, and don't need to be conditioned. So I made an effort at that and added 2 findings on page 4. But I felt I had to keep a couple of. So let me read where we are. Finding number 1, we would find that the proposed use of the site fits meaning of, quote, all other commercial uses under section 270-35 of the City of Rehoboth Municipal Code. Number 2, that the proposed education-related services such as the Arts Institute, as described in the traffic evaluation report dated August 11, 2020, is an accessory use and it is compatible with the primary use. And then the 2 conditions that remain on page 5 are conditions 15 and 16. No, 15, 16, and 17, carrying over to page 6. 15, there shall be no cabaret within the meaning of section 270-4 of the City of Rehoboth Beach Municipal Code. And 16, there shall be no cafe within the meaning of section 270-4 of the City of Rehoboth Beach Municipal Code. And 17, no performances shall be permitted to occur simultaneous with performances in the Rehoboth Spotlight building. And then the Spotlights version of this one would just flip it and say no performances in Spotlight simultaneous with clear space performance. So so the findings are seeking to address the the education related use, the arts, and then there has been public comment about the food service or cafe in the Spotlight building, and so that's what the condition number 16 is getting at. There's been comment about the Black Box Theater in the Spotlight building, and that's what number 15 about cabaret to address, and 17 is the simultaneous performance. So there's also been public comment about office use in the buildings, and but I haven't included anything on that just because I don't see anything in the application that proffers that there's an office use. People are suspecting that there is, but it's not in the application, unlike the educational services, which are clearly explained. So I do have some significant misgivings about these, which I can address after maybe other comments, but the misgivings have to do with the accessory use doctrine, which, as I understand, I'm not a zoning lawyer and I'm not a Delaware lawyer, but I understand accessory use doctrine is an age-old principle, a foundational principle of zoning law that both lawyers that practice in the field and architects know very well. And it seems to me from day one, it should have been understood if the main use here is the theater, then there are accessory uses here too. I mean, you can't miss them. And the educational aspects of the Art Institute is a clear example. The food service in the Spotlight building is another example. And so it's, I think, very unfortunate the applicants never positioned themselves to really justify and demonstrate in the record that these accessory uses comply with the doctrine, which requires that the uses that are customarily incidental to the primary use and in our code, they have to be compatible, I think is the phrase. So, so I struggle to find any evidence in the record that supports these accessory uses because the applicant kind of just walked away from it. They said, we're not a school, so we don't have to comply with any of that. And I think that was the wrong strategy because they only don't have to comply if they're an accessory use. And they didn't try to prove that. And then the last thing I would say is just that I think my theory is the reason why they didn't embrace this issue is precisely because of splitting the project into two properties. And in order to avoid the parking requirements, the accessory use doctrine only applies to each property on its own. Each site has to, if it's an accessory use for that site, then it can be approved. And much of the accessory stuff is going on in the Spotlight building. And it's not really accessory to the Spotlight building itself. It's really accessory to the clear space, right? The main theater is in clear space. The food service, food and beverages in Spotlight. The main theater is in clear space, but the spaces where the classes will be conducted are in Spotlight. So the theater in Spotlight, the black box theater, is actually a fairly small minority of square footage of that building. And it's hard to see how all of this can be justified as something that is customary and incidental, meaning a minor add-on with minor impact, if we're just looking at Spotlight. So let me stop there.
Okay, that was a good explanation and setup. Mr. Coffin's had his hand up for some time, so let's go to him.
Well, first of all, I want to thank Brian for making these two findings rather than conditions. I think that's the right thing to do. I'm fine with 15, 16, and 17. Applicant, by the way, has already conceded to all three of those. With regard to the incidental uses, the finding that these both comply to normal commercial uses essentially indicates that, you know, a small building and some incidental instructions, like if you're in a restaurant, you have some cooking classes. Those are normal and happen, and that's why the condition, the finding that it complies with normal commercial uses is fine. With regard to Brian's other comments concerning ancillary uses in each, there's nothing that says that these two theaters, which are essentially under the direction of one owner, they can't coordinate between the buildings, these accessory uses. They can coordinate with them. The fact that they're on two separate lots and they're two separate buildings is irrelevant to that. It's the management of the theater complexes where they can coordinate, you know, as they bring forward the cultural performances. So I don't have a problem with that. So as I said, I'm okay with both findings, and I'm okay with conditions 15, 16, and 17.
All right, thank you, Mr. Kaufman. Other thoughts? Mr. Covington?
I just wanted to get a clarification on number 16. It says there should be no cafe within the meaning of section 270-4 of the City of Rehoboth Beach Municipal Code. what does that say? I mean, I know they talked about having a limited use permit for food, beverage, or selling soft drinks. I just want to make sure that that's not included in that.
So this is, this is an issue which I don't have an easy answer to. I haven't answered the question yet. The definition of cafe is an establishment, not a restaurant, where food and liquor is served or consumed. Okay. And the reason that's significant is that in the zoning code, there's a table of use regulations for each zoning district. What can you do in that district? And, restaurants are permitted in some districts, but not all. Cafes are not permitted in any districts. And so there's kind of a question though. I mean, a hotel, right? Of course, they've got maybe some possibility of food service that's short of a restaurant in the hotel. That's probably an accessory use of the hotel. Maybe a theater does have sort of an accessory use of food and beverage service. But it does come back to the problem. This is a space in the Spotlight building. Maybe it's not open to the public to just walk in and order food and beverage. Maybe it's really only open to the patrons. So maybe it's not a cafe for that reason. Except that the Clear Space patrons are strangers to the Spotlight building under this framework they presented to us. 2 separate applications, 2 legal entities. Patrons of one are the general public as far as the other building is concerned, unless Mr. Kaufman is right that it doesn't matter and you can coordinate.
So it seems to me that if number 16, if they can't have a cafe, it's already in the law, why are we putting that as a condition? And secondly, if they got a permit from the city to sell soft drinks and wine and candy, whatever it was, that seems to imply to me that the city does not look upon that activity as a cafe. So if the language is ambiguous, they already can't be a cafe anyway, I would rather take that language out.
Okay, thank you, Mr. Covington. Mr. Bryan?
Yes, I agree. And this was a discussion we had previously, that numbers 15 and 16 are already in the city code. And I think that should be a matter handled by the city rather than put in as a condition to this, which I think what it will do is just create more opportunity for controversy. Let's put it that way.
Okay, thank you, Mr. Bryan. I don't see any other hands. Does someone wish to make a motion about 15, 16, or both?
I move they be deleted.
Okay, Mr. Bryan has made a motion that the additional use clarifications, there shall be no cabaret and there shall be no cafe, not be included. Is there a second? Mr. Strange, second. Anybody else want to say anything about that? Okay, so let's have a vote. So the motion is that there shall be the additional use clarification. 15, there shall be no cabaret. 16, there shall be no cafe, will not be included in the resolution. All in favor, please say aye.
Aye.
So that is Mr. Bryan, myself, Mr. Weber, Mr. Covington, Mr. Kaufman, and Mr. Strange. All opposed? Mr. Patterson and Ms. Lucier. And is anyone abstaining? No. Okay. So we're not going to include those 2 additional use clarifications. So Mr. Patterson, does 17 need any other work, or are we good as is? We've accepted that.
I think unless anyone objects, we agree and keep 17. And on the findings, for 1 and 2. Okay, so unless there's any objection, my sense is we agree on finding number 1.
Mhm.
And however, number 2, I do think, I think it does deserve some more discussion and possibly a vote. The issue in my mind remains that ClearSpace didn't show us in the record that the educational programs of scale of what they have delivered up to now and what they propose to continue to do, which is a sort of enormous pride for them and for all of us and joy for a lot of people, that is a customary incidental to theaters in general. We have no evidence in our record that there are any theaters at all in Rehoboth or Sussex County or anywhere else in Delaware that do something like this. And you may each have your own anecdotes of others that do it, but the fact is ClearSpace came in here and just said they don't need to prove that because they're not a school. And however, I think the code it's not setting a requirement for schools, it's a separate requirement for other education related services. And that is defined in the sense of, and this is in 270-15.1, organized schools offering instruction in the arts, crafts, dance, music, undertaken as a commercial venture outside of the normal progression of formal education. So, I mean, that to me exactly matches what a summer theater program is all about and what adult theater classes are all about. And ClearSpace, they refer to these as classes, they call it an institute, they charge tuition, they call it in our record, they offer scholarships. So everything about this meets the definition. And the only question in my mind is it customarily incidental? And ClearSpace, instead of trying to prove that it is, they've pointed to other non-theater uses in the city, like a yoga studio. They specifically mentioned Soulfire Collective in that old building, that yellow brick building at the southeast corner of Rehoboth Avenue and 2nd Street. But that is completely irrelevant. It's a non-theater use, and it's in a building that's grandfathered before the rules were adopted for the parking requirement for educational services. So ClearSpace complains we're holding them to a different standard than the yoga studio. But what we're supposed to be doing is holding them to the exact same standard that all other new projects in the city will be held to if they offer educational services like this. Let me stop there.
Okay, thank you, Mr. Patterson. And I see Mr. Covington. Go ahead.
Yes, I think Mr. Patterson's comment about the discussion of the school, what I heard is that sounded like an all-encompassing primary use was to do those things. I don't think that, the primary use of ClearSpace is for theater. I think the school, the educational part, as we heard, only had 5 classes and was a very small portion of their overall activity. So I would take issue with the clarification of the definition that was given, because I think that in that definition, the primary use is education.
Okay, thank you, Mr. Covington. Did I see any other hands raised? Ms. Lucier, you're muted right now. Go ahead.
I've had 3 grandchildren attend the summer theater sessions. And one of the very good things I found that they do is at 9 o'clock when you go in, you have to bring the child there and you have to sign in. Not last summer, one did it virtually, but the summer before, there were about 45 or so children, 45, 50 maybe, I don't know the number. There were a lot of them. And it would take about 20 minutes. And then you had to sign out at 3 o'clock. Well, on Wilmington or Baltimore, I mean, it was a disaster. The cars were all over the place, sitting there for 20 minutes and honking and everything else. But you don't want your child going in and not knowing whether they signed in or didn't sign in. I think it's a very good practice. But I think that has to be taken into account if, I mean, this was a school, this was an educational thing. And that's just one problem that comes with it. And it's an excellent program. I have another one going this summer.
Okay.
That needs to be addressed by somebody at some point.
Okay, thank you, Ms. Lucier. Back to Mr. Patterson.
Just to fit that comment in the framework. So I think when assessing whether it's an accessory use, it should be ordinarily incidental or customarily incidental to the primary use. So if you agree that it's customary for theaters to have summer theater programs like that, then the next question is, but isn't it an incidental? Is the additional impact of that use incidental or minor? And I think Joyce's point is it's actually a major impact on some of the things we're talking about here, like traffic and parking.
Okay, thank you, Mr. Patterson. Let's see. It looks like Mr. Kaufman. Go ahead.
We can split as many hairs as we want to, but it's very clear to me that these are ancillary uses in a general commercial zone and not the primary use of this facility. And that's permitted in a general commercial zone. The fact that there may be issues at time to time, for example, as Joyce has indicated, where you have a instruction for children, I do think that Clear Space, as they move forward, will have to deal with that, and we'll have to make arrangements so that there isn't this confusion when children are dropped off and picked up. But it's not something that should be a condition per se. And I think the fact that they are findings rather than conditions is the right way to go. But I mean, it's very clear that these are ancillary things, both the office and the instruction. That doesn't mean that there aren't issues with that, as Joyce points out, and which I agree with. I've had this occasion happen in many of the cases I had with daycare facilities, where kids were dropped off and picked up. And it was incumbent upon the operator to work schedules so that the kids were dropped off and picked up in an orderly way, and there weren't great backups that blocked city streets. And that certainly is something I would recommend they make sure that they do as they go forward, especially if their class for children are going to be larger than just a few children. So.
Okay, thank you, Mr. Kaufman. Mr. Strange.
To Stephen's point and to Joyce's point as an ancillary activity, but it brings home the point again of the impact of the mobility options that are going to be taking place, or what we call traffic, that involves not just cars, could be jitneys, could be the public transit, etc. Could be the Jolly Trolley. And they all are going to be queuing up. And I'd like to just, by way of example, because apparently I don't want to get into all the science, but if you look at where they're currently situated on Baltimore Avenue and where the boardwalk is, they're up here. And now they're going to locate down here, which is at the very apex, at the point where everybody comes in to and exits from the city. You don't have much variability. You are very, very tight, very, very constricted. And yet we're talking about here about, well, ancillary use, maybe 40, 50 people, in this case, students coming in 40 or 50 cars, queuing up before and after. It gets to be very problematic. It's not up here, it's down here. And now the impacts are greatly amplified. And that's part of the problem here. We're trying to make workarounds and fits for Clear Space, yet I think we're losing sight of what we're supposed to be doing for all of the residents of Rehoboth Beach. I mean, clearly everyone believes in the Clear Space concept and theater and having those cultural activities in Rehoboth Beach. However, at what price are we willing to sacrifice Rehoboth Beach for that purpose? And I think we're getting further and further astray And it's not a good situation. Thank you.
Thank you, Mr. Strange. I'd like to float an idea. See what you think of this. I'm particularly curious about what information we can get from the chief building inspector in terms of when a site plan is submitted, what is the administrative process? How do they decide that the threshold is met for ancillary use, particularly education-related services? If there even is one, or if something's not, if it's not a school, they don't view it as a school, or if it's something and there's a threshold for where the other services come in. I don't know, whether we can get an answer for this, but I'd like to go to Mr. Janis to see if he'd like to say anything to illuminate this issue. Can Mr. Janis come in?
Sure, here I am. So I would definitely fall back on the fact that Mr. Molina was the original one to review this. Without knowing for sure how he reviewed it and calling what ancillary to the actual use, I would caution to comment. But typically, for site plan review, we're laid out to how we review a site plan and to the things that we look at under the site plan. When it comes to buildings, that's a whole different review of the actual uses, what's permitted in the areas according to zoning, and what's permitted in as far as sizing for the building. I don't know if that answers your questions or not, but again, I don't know what Dom or Mr. Molina was thinking or how he reviewed it at the time. I can only speak for myself and how I would review it.
Okay, thank you, Mr. Janis. Back to Mr.
Yes,
Covington.
Yeah, to follow up on Mike's comment about we represent the public, it's true. I want us to remember that clear space is moving from inside the city, one location to another. So the traffic situation that Joyce commented on Baltimore Street can be alleviated. And, whether or not it's going to cause a traffic situation around the circle, I don't think any of us can say for sure. We can speculate that it might, but I don't think we can say for sure. And also, we haven't talked about the CDP yet. And I know that Mr. Strange is always referencing the CDP, and I had the opportunity to read it again. And there are a few sections that I wanted to share with you. And on page 11 of that plan, under section 2.0, the executive summary, the cities and regions that thrive in the 21st century will be identified by their lively neighborhoods and business districts, cultural and recreational. On page 75, it states, quote, the city needs to encourage creative redevelopment of selected properties on Rehoboth Avenue. And on page 79, the CDP states, in the search for an appropriate means to manage the visual and historic texture of the future, the city realizes that the community design is both an art and a science, and that appropriate solutions are difficult and prey to many political and economic judgments. It also realizes that views or economic needs may not match the views or economic needs of all potential applicants. To this end, the city will examine means to be as flexible, and this is quotes, means to be as flexible as possible in the administration of any regulations to preserve the freedom to build for an applicant who is working to produce a thoughtful and responsive addition to the community. So I think what is key here is that in looking at these applications, we have to be a little bit creative and find ways to create solutions rather than speculate about problems.
You're muted, Jeff.
Okay, we've all fallen prey to that disease of mute. Go ahead, Mr. Strange.
Yeah, I was just saying, I agree with everything that Barry just said, and he's right. I do refer to the CDP a great deal. But what was left out of that, what he just talked about, was there's also sections that talk about minimizing congestion and minimizing the parking issues that we have and minimizing traffic within the city. And the point is that the CDP has to be looked at as a totality. And you can't just look at one particular section and one particular content because it supports your position. That's one of the greatest difficulties I've had with this application, is that I looked at the totality of the CDP and I can't come to a singularly definitive conclusion that says what's the right direction. I keep coming up with a series of almost and maybes and flip a coin, and none of it ends up being truly substantive, and it ends up being sort of piecemeal. And the building code that we have, you would hope that it results in a swan, but occasionally when you take all the bits and pieces, you end up with a platypus, and it's not what's desired. In this particular case, the difficulty, and I agree completely with Barry said, is we have to look in a very creative fashion. But there are hard facts in science related to, in this particular case, what's called, well, it's data envelope analysis, and it's called boundary analysis, where you look at the extremes of certain data where you feel that they pose a serious risk if you go in that direction. And one particular one happens to be in the area of mobility management or the aggregate traffic, and its closeness to the circle. With the example I just gave with the funnel, which I thought was a good way of expressing it without going into all the science. We actually know factually that the propensity for problems are exacerbated by the physical location of the nature of this facility. That's all, doesn't matter whether it's clear space or X space. It's 273 seat theater, which ends up, and you have to look at this in the standout of the build out, not what it is today, but what it's going to ultimately be. And so to Barry's point, where he said you can't just conjecture and you can't just based on I think, I'm basing it on the best facts that I have based on similarly situated situations with things of this nature near close proximity to major arterial activities. There is a real risk here because of this facility being permitted or will be permitted, apparently based on the dialogue so far, at this location. I am totally in favor of clear space, but not in this location because of the high risk to the aggregate city of where it's going to be placed. Thanks.
Thanks, Mr. Strange. Go ahead, Mr. Kaufman, and then Mr. Covington.
I'd like to come back to where we are. We've dealt with traffic. We certainly know where Michael is concerning traffic and its impacts. And several times. We don't need to have him do it again and again on every issue. Where we are is we're dealing with two findings that both office and some construction are within the general commercial uses that are permitted in this zone. So either we should take a vote on them or we'll go on and just have them as findings. I'm open to either, but I do want to deal with this and continue on. So hopefully we can.
Let's hear from Mr. Covington, and then we'll see if we can get a motion.
I think we should follow up Steve's suggestion.
Okay. So would someone like to make a motion to include finding 2, that the educational related services, the Arts Institute is an accessory use and compatible with the primary use?
So
also move, and I'll also move the first one as well.
So 1 and 2, the commercial use?
Office. Yeah, one of them is the office and the other is the educational.
I'm not seeing office use here. Am I misunderstanding?
I don't know. Well, I don't know, Barry, Brian, what was 1?
1 is that the site, the proposed use fits the meaning of other commercial uses.
That one. So I would move both of those.
Okay. Anybody want to say anything else? Oh, wait, do we have a second?
I'll second.
Okay, so those are second. Does anyone else want to say anything? Go ahead, Mr. Patterson.
Yeah, so I will be voting against these findings because I do not believe we have substantial evidence in our record that these things are true. And on the contrary, I think the substantial weight of the evidence is that for the Spotlight project, both of them are not true. And the Spotlight building does not appear to be primarily something other than an educational related services. It primarily exists to provide space for the Art Institute and accessory support for the Clear Space Theater. And the Art Institute activities, in my view, are manifestly education-related services within the meaning of the code. And it has not been shown that they are customary or of incidental impact. And on the contrary, going to Mike's, Mr. Strange's point, they bring a new and substantial traffic impact at a different time of day and different days of the week than the impact that we were talking about earlier.
Okay, anybody else? So then the motions are that we will include findings 1 and 2, that the proposed use of the site fits the meaning of all other commercial uses, and 2, educational related services is an accessory use and compatible. All in favor of those 2 motions, please vote. So we have Mr. Bryan, Mr. Kaufman, Mr. Weber, and Mr. Covington. All those against? The chair is voting against, Brian Patterson and Ms. Lucier and Mr. Strange. So we have a tied vote, so that does not pass. So that means we do not include them. Did I do that right?
That's right.
Okay, good. Okay. Mr. Covington.
Jeff, should we do one finding that, or is that included number 1 about office usage?
Mr. Patterson, you have anything to say about that?
I did not draft anything at all about office use, simply because although there's been public comment sort of asserting that there's an office use, there's simply nothing in the application I could find that shows there is. So it seemed unnecessary for us to make a finding in the negative.
Okay, Mr. Strange?
Yeah, I think with regard to that, which Brian had brought that up before, and prior to him, when this was reviewed prior to Brian joining, coming back to the Planning Commission, it was established that if in fact those rooms no longer were identified as offices, it really is an enforcement issue. An enforcement issue being an inspections by the building inspector, that if they're used in an improper way, they would be cited and fined for it. So it's something that I don't think needs to be addressed at this point at all.
Okay, thank you very much. So it is now 2:29 according to my clock. We have 2 hours left. I believe we have looked at every section once. Is that correct, Mr. Patterson?
According to my notes, you are correct. And the only things remaining to do are see if other members had other things entirely, and then go back over the noise and lighting.
Wonderful. So why don't we go to other members to see if there's anything that we've covered that does not include everything that you wish to cover. Anybody have anything? Okay, well, Brian, you get an A+.
Thank you, Brian, for all your work.
That was great work.
Okay, so then perhaps can we continue to do a review of what we did 2 weeks ago?
Right. So Mr. Kaufman made the point at the top that conditions 1 through 5 on page 4 are identical to what was in the August resolution, and I think we had no comments on it when we met before. So we start with condition 6 on page 5, and so we have 6 through 13 that are noise related, and we have 14 that is light related. Maybe somebody would like to volunteer to read them into the record.
Okay, volunteers, here's your big chance. Help them out.
So which ones were those? I'll happily read.
Okay.
Tell me again, Vice Chair.
I was saying 6 through 14 on page 5.
6 through 14 on page 5. I thought 6 was already okay, not yet. So 6 through 14 on page 5, this is under additional noise-related conditions and additional light-related conditions. Number 6 is air handling units on the roof shall be moved 2 feet to the south of the location shown on the drawing, A104S, and that's for the, that would only be for spotlight. Number 7 is the fire door on the north exterior wall of the building shall have sound transmission coefficient rating of 45 or greater. Number 8 is an additional layer of sound deadening gypsum shall be added to the roof. Number 9, fencing approximately 6 feet tall shall be installed along the north property line. Number 10, 16 trees shall be provided in the area between the north exterior wall of the building and the north lot line of such species and spacing as to maximize soundproofing and privacy and is approved by the city arborist. Number 11, fencing shall be provided between the Rehoboth Spotlight and Clear Space Theater at the north walls of the building to discourage wandering from the patio between the buildings to the area between the north sides of the buildings and the north property lines. Number 12, a water feature shall be provided between the patio, the Rehoboth Spotlight, and Clear Space Theater. Number 13, upon completion of the building and prior to opening to the public, the applicant shall submit to the city manager an independent acoustic study performed with real tests and measurements to verify the compliance of the theater with the City of Rehoboth Beach noise ordinance. That would be for Clear Space Theater only. And then under additional light related conditions, number 14 is subject to meeting the applicable code of the City of Rehoboth Beach, outdoor lighting within 10 feet of the north property line shall not exceed 1,000 lumens and shall be directed or dispersed in such a way as to minimize its impact on adjacent properties.
Okay, so they have been written into the record. One thing I would like to do is just go to the building inspector for a moment to find out if he's had any communication from the city arborist, if there's anything we should know here in regard to item number 10, the 16 trees.
Certainly. Thank you, Mr. Trunzo. Liz has, or Ms. Lingo has been in communication with the applicant. It is my knowledge that they have satisfied all the requirements going forward, and this number 10 is recognition of that.
Wonderful. Thank you, Mr. Janis.
Yes, sir.
Anybody else? Mr. Covington?
Yeah, I have a question for Mr. Janis as well. Are any of these conditions, are they all in compliance with the code? For example, the 6 foot tall fence. I don't want to say they have to put a 6 foot tall fence if the code says they can't, or any other of the other conditions.
Thank you, Mr. Covington. 6 foot tall would be the maximum fence that they could build out there. So that goes along with all kind of shading or screening or anything like that that would be applied out there. 6 foot would be the maximum height.
Thank you.
Okay, Mr. Strange?
Yes, for Matt, on item number 14, on the additional light-related conditions, Matt, what's the minimum amount of light that's required under the fire code with regard to external walls?
I would have to check that. I don't know that number directly off the top of my head, but I would have to confirm that with the code itself.
Okay, the reason I'm asking is I think that this possibly should be rephrased in such a way that 1,000 lumens may be excessive actually per fixture, and per the appropriate fire code. And I don't know it myself at the moment. I can't remember what the minimum requirements are in a commercial area for points of egress and access, but it may be able to be even lesser than this. So I would. That wasn't me. I think it may be appropriate to restructure this one to indicate that it should be at a maximum what is the minimum requirement per the fire code. So I think it would be more beneficial for the adjoining residents if it was phrased that way or some fashion.
Mr. Strange, if I may, I believe it is for exit corridors, it is 1 foot candle. That would be the absolute minimum for for egress, for emergency egress. But again, I would love to be able to verify that number for you.
Okay, well, I think we can do it in the generic and say what is the minimum required, that it shall not exceed what is the minimum required per code. I think I said that right.
Yeah, I think that makes sense. The other issue I'm recalling is there's an interest among the neighbors in the back at having the light softly dispersed rather than concentrated at one point. So I think there might be some things in the record that would help us correct this language already.
Yeah, there's some of the options that you have. It's lighting that doesn't necessarily have to be in the vertical plane. It literally can be at the ground level, similar to the exit lights you have on an airplane when you have an emergency, and they illuminate where your feet are. Because quite frankly, if there's smoke and fire and other things, you may be crawling on your bottom. So I think it would be to minimize it and minimize the light in the maximum way possible per the code.
Okay. I think that's enough direction for wordsmithing. Does everybody feel comfortable with that? Mr. Patterson too?
Yep.
Okay, good. All right. So any other issues with 6 through 14? Mr. Bryan and then Mr. Kaufman.
This is just a question for Michael Strange. Michael, what if the fire policy, the fire insurance companies have a different view? Fire or liability?
That's a very interesting question, and I'm not sure how it would be approached, because if you meet the national fire code, that's interesting. I'm not sure what happens in a situation like that.
It just puzzles me that sometimes there might be different standards according to what their business interests are.
Well, they do. I was going to say it may be their business interest, but with regard to the commercial application, there are very explicit regulations that are required under the National Fire. I can't remember the acronym at the moment, but under the code. So it's beyond our code and the BOCA code. I mean, there's so many different variations on that, but I would think the national standards would apply.
Okay, I just pointed out. I don't have an answer.
Good point.
Okay. Did Mr. Kaufman, did you have something next?
Well, I just needed some clarification. Have we included yet that this one about upon the completion of the north wall, a test in the theater with a SWIFT inside and outside the hall, and then upon completion, a noise monitoring station. Have we touched on those yet?
Are you talking about 13? The acoustic stuff?
Well, my numbers are all confused. I don't have the right page, but I think it is 13. Yeah.
I think Mr. Kaufman may be recalling an additional request, and I think we had a condition in the earlier version. But Mr. Weber and I discussed it, and we dropped it. This is the business of the microphone on the inside, the microphone on the outside, and the noise monitoring that produces data. And my sense was we felt that may be something that come out of the tripartite process, for example. It may be something that if they fail the test at the completion of the building, that they might need to put in. The city might tell them to put it in. But to put it in here at ante seemed unnecessary.
Okay, and then the second part of that was, have we touched on this issue of acoustical absorptive panel to be applied? Is that one of these conditions on the north wall?
I think you're looking at an older version, Steve.
Okay, so that's not okay. That's fine. I just needed to understand.
It's not there anymore. Yeah.
So
Okay,
just a little refresher. At the point where there were going to possibly be patrons in the backyard patio that is between the building and the neighbors, those acoustic panels were suggested by somebody as a way to absorb sounds from conversations and things. But when the when the corral fence limiting anybody's access to the backyard between the two buildings, that eliminated that condition.
Okay, thank you.
Sure. Okay, I see no other hands being raised. So do I dare say that we have completed our review of this draft resolution?
Do you want to have a resolution to adopt finding of these 6 through 14? Do you want to have a vote, straw vote of some kind?
Sure, we can do that. Yeah, why not? So do you want to finish making that motion, Mr. Bryan?
I so move that we adopt matters 6 through 14 under additional noise-related conditions and additional light-related conditions.
Is there a second, please?
Second.
Okay, there's a second. Everybody ready to vote? Okay, all in favor of the motion made by Mr. Bryan to adopt 6 through 14, please say aye.
Aye.
Okay, looks like we have everybody, no nays and no abstentions. I think we now have a fully piecemeal adopted resolution, and we are ready for final steps. Does everybody agree with that? And the final step would be for a motion to be made to either approve, deny, or approve with conditions what we have in front of us. So I'll be quiet and see what comes up. Mr. Kaufman?
I guess I'll move that I move to approve this application with the conditions we've agreed to in these work sessions.
All right. Is there a second for Mr. Kaufman's motion? Okay, do I see Mr. Weber as a second? Okay. Is there any other discussion or any amendment anyone would like to make? Mr. Patterson.
Just for discussion, maybe I'll run through what I think we're including here and excluding.
Yes.
Perfect.
And bearing in mind, this is a single motion to approve the resolution for both sites, or should we do this first for one and then do it again?
I think it's for both because with the necessary adjustments in terms of application number, et cetera, rather than go through this twice.
Yeah, let's let Mr. Mandelis weigh in on that one too.
I think it's fine to do one motion as to both, but when you vote, I want you to be very, very clear about why you're voting the way you're voting. And you can rely upon things that other people said about why they're voting, but be clear if there are certain things that were important to you that you heard that are on the record that relate to spotlight and don't relate to clear space. Try to enumerate some of those so that it's clear on the record as to why you're voting, how you're voting as to each of the applications. Judges have said they're not going to go trying to look through the record to figure out why an individual voted the way they did. This is a very important part of the process. So you want to take a moment and explain your reasons for why you're voting. If you hear something that somebody else said that you particularly liked, you are more than welcome to rely upon those same reasons. But Brian, thank you for volunteering to go through the resolution and explain what's in and what's out. That's helpful.
So my understanding is starting on page 4, findings 1 and 2 are out. Finding 3 is in. Conditions 1 through 14 are all in. 15 and 16 are out. 17 is in. 18 alternate 1 is in.
Right.
19 alternate B is in, except that subparagraph D is out. 19 alternate C is out. Alternate A is out. Alternate D is in. And 20 is in.
Right.
Wonderful. Thank you.
Brian, can you go through number 19 again?
So 19, this is under the heading traffic and parking conditions. Alternate A is out.
Okay.
Alternate B, as in Brian, is in, except that subparagraph D is out.
Okay.
Alternate C is out, and alternate D, as in David, is in.
Okay. Thanks, Brian.
Okay, is everybody clear on that? All right. So for this part, as Mr. Mandelis has instructed us, we will state our vote, or I guess you could state your vote at the end, but you'll give your reason for how you voted for the record. I'll ask the secretary to call the roll alphabetically. The chair will go last, and this will be for both resolutions. And if you do have something specific that you can recall or want to make sure goes into either clear space or Rehoboth spotlight, in terms of your reasoning, please also call that out. Anything else I should say before we get started?
Yeah, if I could, if for some reason you're voting yes as to one and no as to the other, explain that as well. Remember, am I correct, Vice Chair, that the resolutions are dependent on each other? If one of them isn't approved, the other one is not. But there could be a case where one of you wants to vote in the affirmative for one, the negative for the other. Just make that clear on the record, please.
Okay, thank you for that clarification. And Mr. Patterson again.
And one other clarification I didn't mention, and it's not in the draft that you have, but Mr. Bryan had a good suggestion for an additional whereas clause that we would add. I could read for you if I have it in front of me.
I happen to have it if you'd like me to read it.
Please go ahead.
So it would say, whereas the Planning Commission has considered the factors set forth in section 236-30E of the Municipal Code, which allows the Planning Commission to attach conditions or restrictions when such conditions or restrictions are consistent with the general purposes of section 236-30D of the Municipal Code. Clarifying that you can attach the conditions, and this is a conditional resolution, so it made good sense to include that.
So I include that in a motion.
I'm sorry, Mr. Kaufman, I didn't hear that.
I said I include that in the motion.
Oh, you
I accept that as an addendum to the motion.
oh, okay.
And who seconded the motion? There hasn't been one
I think Lee did, I believe. Yeah.
Okay, so let's make sure we have our second then. So since you made a motion to add it, could we get a second to what Mr. Kaufman just proposed? Okay, Mr. Covington will second. Okay, so now we have a properly motion and seconded motion. So I think we're ready. No other questions. I think we're ready to start the roll call of the vote. Mr. Weber, if you will.
Are you voting simply on the whereas, the additional whereas clause?
No, the whole thing.
I thought we were voting on the whole thing. Thank you.
Okay, thanks.
Okay. Thank you. Okay, Mr. Weber.
And Mr. Bryan.
This is quite a project as one of the newest members of the commission. I'm not sure what's next, but I don't think it will exceed what we've had to work with here. I will vote for both proposed site plans with the additional conditions. I find that they are consistent with the Rehoboth Beach Comprehensive Development Plan as currently in effect. I find that these applications strike a reasonable balance with the goals of the Rehoboth Beach Comprehensive Plan. These proposed site plans with additional conditions meet the requirements, in my view, of the Rehoboth Beach Municipal Code, including but not limited to chapters 236 and 270 of the code. I think that these conditions help address concerns of the public about traffic, parking, light, noise, use, and the other concerns raised by those who did not favor these applications. So my vote is aye to both.
Okay, thank you, Mr. Bryan. Next,
Mr. Covington.
Mr. Covington.
My vote is to vote for approval for both parcels. I had written a long statement of my support and reasons for it, but rather than reading that, a lot of which would be redundant to what I spoke about earlier, but in making my consideration, I too looked at three factors. One was whether or not it was code compliant, analyzing the 21 factors under section 23630. I think that the issues concerning traffic and parking have been addressed. And I think that the applications both meet are code compliant. I talked earlier about the CDP. I think that they're compliant with the CDP as well. And I think thirdly, and this isn't really a factor in terms of whether or not it's should be approved or not approved, but I also have to look at the community. And we had a smaller group of appellants who are opposing this, primarily many of whom live in the area and feel they're going to be impacted by it. But on the other hand, we have a great opportunity here. We have a great institution that I've heard everyone say that they hope it stays in Rehoboth Beach. And I hear that over and over again. And if not at its present, at its new location, where? This is a small town. And I don't think there are many parcels in a commercial zone district where clear space could go other than where it's going now. So reasons that it is code compliant and is compliant with the comprehensive development plan, plus I think it's a great asset for our city, I vote for approval in both.
Thank you, Mr. Covington.
Ms. Lucier.
Yes, I am voting against the application before us for clear space.
I'm sorry. I'm so sorry to interrupt. But Mr. Weber, should it be Mr. Kaufman next?
Yes.
Oh, I'm sorry, I missed Mr. Kaufman. Sorry, Steve.
Well, that's all right. Let Joyce finish and then I'll go. It's fine. Go ahead, Joyce.
Is that all right, Jeff?
Yeah, it's fine. Sure.
Okay.
Yes, totally. Thank you.
Okay, I'm voting against the application that's before us today for the Clear Space Theater and for Spotlight at the proposed location on Rehoboth Avenue. I want the residents and the neighbors to know that their concerns have been heard. I do wish Clear Space Theater all success. It is a great addition to our city. I want the city and planning commission to retain our reputation for diligence and fairness, but there remained many allegations and unanswered questions about our process. But since this body, our body, has decided to vote today, I'm voicing my opposition. And I would like my opposition to be on the record and that my dissent is clear. Some of my objections are the following. The main one being the safety and the parking problems that are numerous. I won't go into all the others because we've been dealing with them. And I am very pleased with the additions or the conditions that have been put on. One of the things that has been a problem for me from the beginning is the creative language that has been used by Clear Space from the beginning to circumvent our code. So basically what Clear Space is proposing is an improper location for this or for these structures. Someone said at one of the meetings that it was the wrong building at the wrong place. And I agree with that. But I wish them, I know it's going to pass. I wish them the best of luck and I hope we can deal with the problems. Thank you all for all your cooperation and work.
Thank you, Ms. Lucier.
Okay, I'm sorry, Steve, but back to you. I looked away from my list for a minute and I went back and missed you.
Thank you. Well, first, I am voting for it. Second, I want to thank all my fellow Planning Commission members for the work that we've done here cooperatively and in the best spirits for the benefit of the city. And especially Mr. Patterson for the hard work he's done. I don't think we could have done this without what he has set before us and walked through it. And especially since a lot of it is things that he has a problem with. So I want to thank him for that. I want to adopt the statements of both Mr. Bryan and Mr. Covington in total as part of my approval. I don't need to repeat what they've said, but I agree totally with what they both said. I think it's something to understand and note that, you know, the standard for review on a case like this is whether it's fairly debatable. That's the standard. In other words, is there sufficient evidence in the record to support the finding by a reasonable person considering the evidence in the record? I think there's more than substantial evidence in the record to support this application and that it is not in any way arbitrary or capricious. I know that there will be impacts from this construction of this theater. I think it's important to note that Rehoboth is a city. It's not a hamlet, it's a city. In many ways, it functions as the downtown for Sussex County, Delaware, which is the largest county in the state. For it to have an opportunity for a cultural aspect such as clear space is a remarkably good thing. I think it's in complete compliance with the CDC that is adopted. Certainly in anyway, once we could get to that. Let me just see if there's anything else. I think the conditions that were added are very good. And I think the other thing is, you know, we want the things that we do as a planning commission to put the people in the city in no better or worse condition than any other people in the city. And you have to look at it comprehensively as the overall city. The city of Rehoboth does have a parking problem, but it's a general problem of the city. It's would not be caused just by this particular use. And although I understand the opponents' problems with the impacts that will come from this relocation of clear space, anywhere else it would have gone, if there were any other place, would have had the same issues. So I'm very, very pleased to vote in favor of this application.
Thank you, Mr. Kaufman.
Mr. Patterson.
Thank you. I will vote no for both. And I will adopt the statement of Ms. Lucier, with which I agree, and supplement it with the following points. First, I do not find the application as code compliant. I do think it is an abuse of discretion for us to proceed on the basis of drawings the applicant has now admitted were incorrect and uncompliant. And material addenda were omitted, and that has gutted the public process, depriving both this planning commission and the public of a fair opportunity to be heard on the project. And it's unfortunate they did that because the solution is so simple as resubmitting the full set of drawings to us in a new application. And they have a 5-year lease in their current location. There's plenty of time. Second, I think there is not substantial evidence that the educational uses proposed in the two sites are customarily incidental to the permitted uses. And on the contrary, there's substantial evidence that the Arts Institute is unique in its scale, far more than what a typical community theater would provide, with impacts that are not incidental, but very substantial at a completely different time of day, different days of the week than the traffic and parking impact of the permitted theater use. Third, I see substantial evidence the food establishment in the Spotlight Theater is primarily to serve the Clear Space Theater patrons at the other site. It is therefore not an ancillary use of the Spotlight Building. It is not customarily incidental to the permitted use in the Spotlight Building. Fourth, I do think the submission of the two separate applications improperly subverts the letter and spirit of the zoning code for what is obviously a single campus, fully integrated and codependent. And finally, on the traffic and parking issues and the pedestrian safety, the conditions we have are far from sufficient. The CDP is our North Star to guide the choices about growth, preservation, and the character of the city. And an enormous part of the character of those neighborhoods abutting this site on the north side of Rehoboth is the absence of sidewalks, the absence of marked crosswalks, the absence of marked parking spaces, the absence of even paved shoulders on streets like Columbia Avenue. The proposed intense use of these two sites is incompatible with the character of the neighborhoods abutting it. It is unsafe to attract such a high volume of people to walk after dark in these streets. The city will undoubtedly have to make drastic changes to these streets, which will drastically change the character of the neighborhoods. That is foreseeable. It's the right thing to do for public safety, but it is not compatible with the CDP to impact the character of those neighborhoods in this way.
Thank you, Mr. Patterson.
Mr. Strange.
Thank you. I had also written a brief as to what I was going to say, but I think that Mr. Patterson and Ms. Lucier had enumerated and explicated several of those. I am voting against both applications. I believe that the application is not in accordance with the CDP. And I think that the reason that I think that is that the CDP can be translated in many ways. And it's really intended to look at an aggregation of the values that we hold. And sometimes those values may occur at extreme locations and extreme positions. And we have to look at those and see if the best interests are served. Under our charter, within the state and within the city, explicitly, we have to promote the health, safety, prosperity, and general welfare, and specifically secure safety from fire, panic, and other dangers within the city. By physically locating this set of buildings at this physical location, we are putting the aggregate city at risk. Now, the clear space folks, I completely support their objectives. I completely support them being within the city. But if being within the city means we put the aggregate city at risk, then there's a danger. And the danger here does happen to be related to transportation. It's because that is, as I pointed in my little funnel example, without going through all the science, we know and we have the facts and the evidence based on knowledge that this is going to create a difficulty for the city. And the first time that accident happens, meaning an event takes place where egress or access is limited and fire and police cannot get to where they need to be, there's going to be hell to pay. And then people are going to look at that and say, what were we thinking when we approved this? We should have known that this could have happened. Now, I'm not saying it will happen, but it's a high probability. And that's one of the things that you do when you do an analysis, is you try to get it so that the results will be, you can recover if you're wrong. In this particular case, because we are now approving, I'm not approving, but it appears that it will end up passing, we're approving a facility that puts the city at risk. And I think that's inappropriate. Thank you.
Thank you, Mr. Strange.
May I ask Mr. Strange one question about his vote? You referenced Mr. Patterson's and Ms. Lucier's comments, but I didn't hear you specifically incorporate them within your reasons for rejecting the application. So I want to be clear, are you incorporating the reasons or not?
Yes, I am. I'm incorporating their reasons and I agree with them.
Thank you.
Thank you. Mr. Weber, I believe that's you next.
Great, thank you. I also would like to incorporate or adopt, whatever the appropriate term is, the comments of Mr. Bryan Mr. Covington and Mr. Kaufman. I've, been working on this for a while. I've looked at a lot of things a number of times. I looked at the C1 district and looked at some of the uses other than theaters that are permitted on this site, which include things like a hotel, a motel, a fire station, a public parking lot, a restaurant, a theater, a pool hall, a bowling establishment, a miniature golf course, a utility building, a printing and engraving shop, a hand laundry, a dry cleaner, a private club or lodge, a self-service laundry, a commercial court, a health club, a public garage, and an undertaking parlor. So looking at that and understanding that ClearSpace is a business in town that wants to stay in town. They just want to expand. I agree with Mr. Covington that commercial sites are few and far between. And I think with the conditions that we drafted that I thank Mr. Patterson for working so hard on, that I think we have come to a compromise between the needs of the city and the property rights of an owner to develop their property. I have, like I said earlier today, I have a lot of confidence in the city staff and the applicant that they will address issues that come up. I get the sense that some that have voted no don't have that confidence in the city staff, that they think that issues that may arise just won't be able to be dealt with. And I just don't feel that way. As Mr. Brian Covington and Kaufman said, I feel like it's in compliance with Chapter 270 of the zoning code. It's in compliance with 236, which is the site plan review. It is compliance with the CDP, and for those reasons, I will vote for both applications a yes. That leaves you, Mr. Kizzo.
Okay, thank you, Mr. Weber. So I'm going to say begin by saying that I am voting yes for the application. I do want to adopt the statements of those who voted before me to approve with conditions, Mr. Bryant, Mr. Covington, and Mr. Weber. However, I also wish to adopt Mr. Patterson's first 2 points about the drawings and about the educational use. And my reasoning for those is perhaps different than other people's, because having been in the pilot seat for this project for many months, I am adamant and firm that I will not do another large commercial redevelopment as chair for the city without the engagement of a professional planner. It is absolutely an impossibility to do this right. These loose ends would not happen if there was a director level person who could iron all this stuff out. And I think it's not our fault, because we certainly tried our best, and we're a large group of people. It's not the city's staff fault. They work very hard. It's not the applicant's fault. They worked very, very hard and sought direction and guidance on processes, and even their representatives. I think the system does not work without that point person for the city. So I think it's been incredible education by fire experience. That being said, I do believe that the site plan review has been based on a full and complete record going back to June 2020, and it's been amply supplemented with new information since the remand from the Board of Commissioners to the PC. There has been more than enough time for the public, applicant, and the PC to supplement, review, comment on, and deliberate the full and complete record, and we've done that. I believe that the application appears to be or can be made fully compliant with the zoning code. And on this condition is where I'm hooking to Mr. Patterson's comment. And I believe that the applicant intends to meet the zoning code as well. And I do believe that the conditions in this draft resolution assure that the final construction documents will be verified as fully compliant. I also believe, and this is where individual differences in readings of the CDP come into place and create some of the difficulties that Mr. Strange mentioned. I believe that the plan far exceeds the requirements and goals of the CDP in many ways. Not every page, but in many very specific ways that I think few of any of the businesses that could locate here would match, to Mr. Weber's point. Number one, it's a destination that draws people into the city for cultural enrichment. It operates year-round. It enriches the lives of residents and visitors. Once in town, theater patrons will be inclined to dine, shop, and stroll Rehoboth Beach, increasing the vitality of the city. This is a retention of a core business that builds a year-round commercial base and brings people to downtown Rehoboth Beach during the off-season. Since ClearSpace is already here, I don't believe that it's a net new addition to traffic congestion and parking demand. I believe that it's the responsibility of the city to have a peak seasonal demand policies about traffic congestion and parking. I note one other thing. An auditorium and performance space are welcome additions to Rehoboth Avenue and are much needed amenities, especially for an engaged community like ours that has many useful meetings and gatherings. I point everybody to the very highly regarded A Sense of Place program of November 2016 by Ed McMahon, a noted urban planner. Most ironically, in my opinion, this meeting was held in a second floor, inaccessible room with the little of the sense of place espoused by Mr. McMahon. I think this project brings something very important to the city this meeting. So I have a whole bunch of pages from the CDP that I believe that this project far exceeds what the CDP asked for. But I'm going to read only one in the interest of time. And that's chapter 9.0, page 95, Growth Management Development Controls. And it says, to do its job efficiently and effectively, the PC needs to be able to operate with up-to-date ordinances, have access to a professional planner on a regular and continuing basis, and offer creative solutions such as incentivized zoning in special situations. We needed all of those things to make to give a quick, efficient, complete review. We did our best. So this is in the 2010 CDP. I think the situation has not improved. I think it's worsened because I think the commercial redevelopment pressures are even stronger now than they were 10 years ago. So I'm just stating for the record, my opinion that after this experience, I don't want to see the PC put through another large commercial redevelopment project without the city's planner on staff or on contract to help us. And I will stop there. So the motion has passed. We approved with conditions that we outlined before. The process will be that the resolutions will be administratively finalized within a few business days. We're going to do editing and reviewing for accuracy. There will be 2 resolutions, one for each project. And if there are no other comments, we can conclude these site plan reviews. Mr. Mandelis, is there anything I've overlooked?
No, I think you've gotten there sooner than you anticipated. So well done.
Okay, thank you so much. So let's continue with the agenda. First, I have to find mine. Okay, we are to the citizen comment period. So while Brant gets ready to let people in, I want to mention the note I included on the agenda. So citizen comments are encouraged and appreciated, However, because the public record of the Clear Space and Spotlight applications is closed, further comments on the merits of these applications will not be received by the Planning Commission during this period for citizen comment. So I ask very kindly at this point that those who have patiently waited through the many hours of this meeting, please feel free to make your comments, but please take my suggestion to heart. Stay away from the merits of the applications in your comments, and I will be polite, but I will interrupt you if I feel like it's interfering with the record. So, Ms. Womack, can I go to you for a moment? I don't think I have a list of speakers. Did I overlook that?
I did send one over to you this afternoon.
Wonderful. Hold on.
There should be one for the applicants and the representatives, and then another list for the actual public.
Wonderful. I'm looking at my email right now. And okay, so I'm going to open applicants and representatives first. I do have it. And the folks signed up are Mr. Paulson, Ms. West, and I'm sorry, Mr. Paulson, Ms. West, and Ms. Mason. Can we bring Mr. Paulson in and see if he has anything to say?
Thank you, Mr. Chairman. I would like to say, please let me know what I can do for you and the city staff in coming up with the position of the, I forgot the name of the title, but the development designer, a staff person to help guide applicants through this process. I think it would be helpful for all concerned, and Clear Space stands ready to do whatever we can to advocate on your behalf. Thank you.
Thank you, Mr. Paulson. Donna West, Ms. West, would you like to come in?
Yes, I would. Thank you so much. I would just like to say on behalf of the board of directors for Clear Space Theater, for our patrons, for the city of Rehoboth, you've made us very happy. So thank you so much.
Thank you, Ms. West. And Ms. Laura Mason.
I would just like to second Donna. Thank you all so much for working with us through this process. I know a couple of years of work, and we thank you for all your time, energy, and effort.
Wonderful. Thank you, Ms. Okay, let me open the other attachment. All right, so we do have citizens signed up for public comment. I have Suzanne Good, John Swift, Jan Conacy, and Harvey Schulman. Could we go to Suzanne Good, please? If she's still with us. I believe she is.
Good afternoon, members of the Planning Commission and others in this hearing. I actually won't be commenting on the merits because, in my view, the current site plan at the location on the avenue 413 to 417 Rehoboth Avenue has few, if any, merits. So I will be talking about the inherent deficiencies and problems with this. For background, most planning commissioners themselves, and certainly including the 5 who just voted to approve this, aren't affected by this particular location as they reside nowhere near it. In fact, in many ways, by the certainty of it going in at that particular location, it follows logically there's no chance this theater will be fairly close to them, let's say on the shores of Silver Lake or vicinity. So in fact, they increase the chances that they'll never have to suffer any of the externalities from a 256-seat theater. So there was some lack of clarity about when we would be able to comment. And now that the vote has already been taken in favor, I want to go back to things that happened during this particular meeting first. We had Commissioner Michael Bryan suggesting that Clear Space Theater be given an option of hiring a third party for traffic control and to develop a traffic mitigation plan. This was in case the city's police department and the extremely busy city manager were unable to handle that task, which may well happen. Well, none of this would be necessary if Clear Space Theater had, beginning in April of 2019, followed the spirit of the building code. Instead, we have these requests that Clear Space cooperate. We have these tenuous parking agreements they're supposed to enter into, which are problematic for a lot of the reasons I set forth in my public comment on, I believe, January 29th, or it might have been February 12th. In addition to all the, overall, I feel what the Planning Commission has just done is to use indirect and ineffective means to address the parking needs of a big facility, of this big theater. And as you know, I have felt from the beginning, many of the street conditions were described better than I could myself by Commissioner Brian Patterson, in terms of the lighting and the lack of sidewalks and the shoulders that then become the parking area, and therefore the pedestrians are thrown into the roadway. I was also disturbed by two facts presented today. Commissioner Covington said that Clear Space holds 5 classes. I assume he implied per year. Well, we had Mr. Paulson at an earlier meeting in January say that there were 12 classes total, but then he corrected himself and for the record and said there were 11. But so we have a planning commissioner almost aiding and abetting a theater to reduce classes, which are sessions, which have, in the case of the summer camps, they run 5 days a week from late June until early August. So we're not representing the facts accurately, and that's been done multiple times, including with the parking situation at the Cape Henlopen Senior Center and other misrepresentations of the facts. I will give you one anecdote because I was acquainted with a real estate developer whose children, like my youngest, were at Cape Henlopen High School in the past couple of years. And he said, just out of curiosity, after reading about the December 30th, 2019 closing on these 3 lots, that he took a drive-by. He does not live in town, but he's a real estate developer, so he has more background in this than I would as a layperson. He looked at the 15,000 square feet, and he said he almost laughed at the scale, that it was so inadequate. You would want not only parking and a drop-off pickup area, but you'd want space for outdoor gathering. And now in a pandemic age, you might want to look toward outdoor theater festivals, which would mean even more acreage. So the parking issue has been the one that has bothered me the most, because I feel that Clear Space Theater deliberately engaged in presenting a false narrative about the parking garage. And today, Mr. Covington even went so far as to say that an underground garage with a ramp is unsafe. So I'm not sure how any of the hotels in this town would meet code, because they have garages partially underground or with ramps. So Mr. Paulson,
Ms. Good, I'm sorry. Can you? We're pretty much into the personal.
Please could I just finish with this thought about?
I was going to.
I'm trying to, and we're not. So and you've helped me. I just lost my train of thought. Oh, that Mr. Paulson spoke to several news outlets in early 2020 with the narrative that the neighbors didn't want a parking garage. That was not true. Some of the immediate neighbors behind Clear Space, and I'm not one of them, were worried about the noise, the fumes, and the headlights. What they didn't want was an unenclosed parking garage. But Clear Space Theater, I hope not deliberately, but they hijacked this to present to the press and the public that somehow the neighbors didn't want a parking garage. We want a parking garage. We want it for the same reason that any community considering a 256-seat theater would want on-site parking to mitigate the effects on nearby streets, on congestion. And now I see these options don't even include a drop-off pickup ingress egress. If I understand correctly, that's being removed. So the travel lane will become the drop-off pickup area. Whereas if you have on-site parking, people just drive in, they don't block the westbound travel lanes. And I'm also finding this idea that ClearSpace will encourage the use of public transportation. This is the wrong demographic. These are people who are theater goers whose time is very valuable to them. They value the convenience of using their cars to park nearby, and some of them even go so far as to bring two vehicles. It's called trip ticking. One of the parties attending the theater needs to make a stop either before or after the show at some other location. Let's say the Giant Food on the way home. I'm guilty of it myself when we lived in the suburbs.
Okay.
My husband and I would attend something, and we needed two cars.
Let's wrap it up in a second.
So, in summary, I'm hearing today what I've heard for many, many months, actually beginning July 10th, 2020, if not even earlier, that the Planning Commission is not taking steps to impose reasonable parking requirements on a complex, which in no reasonable world is anything but a large complex, and the buildings don't have any meaningful, distinct purpose. They're integral.
Thank you, Ms.
Thank you very much.
We're going to stop there. Okay, thank you so much. Could we go to Mr. Swift next? And we will set the timer at 3 minutes for Mr. Swift. And if that's not enough time, would you please let me know?
Sure. Can you hear me now?
Absolutely. Go ahead.
Okay. I'd just like to start out to make the message. The neighbors on Sussex Street have never been opposed to this project. We've always been work with the neighbors, put in a code compliant project, and work with us and be reasonable. From day one, when this project came in, it was never code compliant. They've tried to circumvent that process. But the most recent thing is my character has been assassinated in this process. I want the record to be correct. Mr. Trunzo is mistaken that he heard a call with me and Mr. Mandalis on January 29th. There were never any calls with Mr. Mandalis and me. There were only email messages. Since everyone is talking bar rules and that Mr. Kaufman suggested a bar complaint is the place to resolve this ethical question, that seems would be the next step to ask the bar to act. That way the bar can make the decision based on the written record that there is. This will be similar to the way the PIC told Ms. Maka that she needed to recuse, as they stated on the email to me on 2/16. They wrote, the Public Integrity Commission is advising Ms. Maka that she must now recuse herself for the proceedings related to the clear space, as well as any other matters pending before the Planning Commission related to the group of residents referred to as the neighbors until the pendency of this complaint has been resolved. Thank you.
Thank you, Mr. Swift. Okay, so that brings us to Ms. Conacy. Can we bring in Jan Conacy?
Okay.
Go ahead, Jan.
Thank you, Jeff. I really wanted to talk about Rehoboth Beach because many of you today made comments about Rehoboth, and I would like to clarify. Rehoboth is not a city. Rehoboth is 1 square mile. Unlike the Wall Street Journal, we know that it begins at the canal, east of the canal. It does not include North Shores. It does not include Henlopen Acres. We are 1 square mile. We have a very strong sense of place. And back from the 70s on, people have worked their butts off to maintain it. We worked hard. I mean, I've been in Rehoboth, my husband since the early 50s, me since the early 70s. We have worked very hard to maintain height limits in Rehoboth. We have fought tooth and nail, and the Homeowners Association has a long record of maintaining our height restrictions, even though they are the highest in Sussex County. But that sense of place, that sense of nostalgia that you get here. I know that Ed McMahon, I was one of the people that brought Ed McMahon here, and we brought him to the fire hall. The fire hall in the small towns in Sussex County is the centerpiece of the town. If you have nieces and nephews, I don't have grandchildren, but I have nieces and nephews and great nieces and nephews and my own children. Used to go into the fire hall and the firemen would let them climb on the trucks. Those are part of the things that make us a town, a real living town. The fire hall, the post office, the library. We fought to keep the library in Rehoboth in the 90s when they wanted to move outside of town. Built them a building, gave them land. So we work hard for those things. The fire hall is ADA compliant. There is an elevator, and many people took the elevator up to the second floor for Ed McMahon's presentation. It was a perfect place to hold his presentation. The center of our town, next to City Hall. We are not the downtown of Sussex County. I would say that Seaford and Millsboro and Georgetown and Lewis Milford would fight us on that one. We are a resort, but we're also a resort where people live and work every day. Most of us are retired. We care tremendously about this town, as you all see from the citizen reaction you get. People commented, this is not a popularity contest. 200 people might have signed a petition. If you had asked, we could probably got 500 to sign it against it. It wasn't difficult. But we haven't. What we've said is that we need to preserve the town that we have. We need to preserve it for our residents. We need to be able to get out of the north side of Rehoboth onto Rehoboth Avenue between 4 and 6 and 7, Monday through Friday, Saturday and Sunday. It's like it's a mob scene all the time. We need to protect and preserve what we have. And if you look at the CDP, one of the things they talked about was what makes a town. The post office, the library, the dry cleaners, the drugstore, where people meet. Now it's out on the highway. So I think also the restaurants and businesses out on Route 1 would have a little problem with saying that Rehoboth Beach is the downtown. Where people come to have fun? You see people all the time. I see them in my neighborhood. They come in their SUVs with their bike racks on the back. They park their car, they get off their bikes, they ride around Rehoboth because it's so much fun to ride around here. Then they get in their bikes and they leave again. I don't have a comment about clear space, but I do think in the time that I've lived here, in the 40 some years I've lived here, I have never seen an applicant who absolutely and totally is unwilling to compromise on what they want and has very little concern or regard for the neighborhood or the community. And that's the end of it. Thank you.
Thank you, Jan. And let's see, next we have Mr. Schulman. Can we bring in Mr. Schulman, please?
Can you hear me?
Yes.
I have a question first. You've indicated that you're going to be tweaking the resolution. Some of the conditions are going to have some of the language changed. It was a little hard to follow some of the discussion on what the language will be. So my question is the appeal period going to run from the time you actually post the resolution that you've all signed off on the final words? Or is the appeal period running from today? Because this is not a typical thing where, we're correcting grammatical errors and that sort of thing. There was a lot of substantive discussion about what the resolution would say.
You can continue with your comments, Mr. Schulman.
Well, what's the period for the appeal?
I'm not prepared to answer that. I don't have the answer to that right now. But
yeah, frankly, I don't either. I'm gonna review the code now, and perhaps by the end of the discussion, we'll be able to give an answer.
That would be helpful, because obviously we don't want to file an appeal late, but we don't want to file it early and not really understand what was adopted. So thank you. Okay, I have my comments. So my comments are mostly directed to the process here. There's been remarks made by Mr. Patterson and others about the integrity of the process in the case. And I have a very serious concern about that. Some of that relates to what Mr. Trunzo said. This process for approving these applications stinks. And one of the things that stinks about it, and it's not the fault of any one person, but among other things, you have a city solicitor who advises the building inspector, is this plan code compliant? Then the planning commission is actually supposed to look at what the building inspector did and see if it agrees with that or not. This is the way it's been done for at least 25 years. We never just said the building inspector said it's okay, and therefore we don't make an independent judgment. There was no deference. There was looking at the facts and making our judgment. But in this case, on a and about 20% of the time, the planning commission disagreed with the building inspector about whether it was code compliant. But in this case, you had the city solicitor advising the building inspector that it was code compliant. And then you had the planning commission asking the city solicitor if the building inspector was right that it was code compliant. And the city solicitor was put in a position of having to tell you whether he made a mistake, whether the building inspector followed his advice. Then you go to appeal to the mayor and commissioners, who, by the way, are the city solicitor's client on just about everything else that goes on in the city. So you all, as a planning commission on these appeals, you're a party. You have insight into what the mayor and commissioners think generally about things, because your attorney in this case happens to be the attorney for the mayor and commissioners on just about everything else. That is an awful process. Related to that, it was complicated by the fact that one of your commissioners obtained a copy through an ex-parte communication of a document. And then the record will show, and I'm not going to go into details here, that that person was in regular communication with the city solicitor, who was advising her on questions related to, or at least speaking for her, sending messages for her on whether she was personally defamed, whether her job was in jeopardy. Who's representing who in this matter? The process is bad. I also want to comment on the question about extra record evidence and how that fits into the process. A few of you stated, well, there was no extra record evidence, or it's cumulative. As will be shown later, that is not the case. The memo that Ms. Macha put into the record contained new information that was not put into the record. You all posted it just about a week ago so the whole public could see it. And it was posted after you closed the record on February 5th. After you closed the record on February 5th. So you yourselves put that information out there, and it's in the ClearSpace file on your website. The ClearSpace update that was filed the last couple of days, responding to the proposed conditions and the resolution. You posted that yesterday or the day before. That has information that's not merely cumulative, but information that goes beyond what was previously in the record. There was also the building inspector's comments today. You can describe them any way you want, but the fact is you were given information today about the way the building inspector office handled this that was not in the record before today, and you relied on that information. So this whole notion of the record being closed is really absurd when you look at the facts of what's happened. That's not a way to have a process. Either you close the record or you don't close the record. And by the way, the record was also expanded when ClearSpace answered your questions at your last meeting, not today, the prior meeting. There are some things they said about gathering licenses, et cetera, that nobody ever heard previously. So you have destroyed the integrity of this proceeding by letting some people, including the applicant, supplement the record, but not the public. Now I want to make a comment about the process and code compliance. And Mr. Trunzo, this all goes to your comments about how to avoid these problems in the future. Okay? All of you, or just about all of you, have made comments over and over and over again last summer and even in the past few weeks of meetings that this is a code compliant plan. It's a code compliant plan. It's a code compliant plan. Well, that's very interesting. I just found out today that you didn't have a copy of the actual plan that the building inspector supposedly said was code compliant. And you all agreed was code compliant. Even before hearing from the public on that point, you made those comments. And now we find you weren't even looking at what the building inspector eventually looked at, and neither was the public. So please, when you talk about code compliance in the future, wait until you hear from the public on their views about code compliance, because that's what a public hearing is for. And don't reach a judgment about code compliance before there's even a public hearing, especially when you haven't even seen what the building inspector looked like.
Thanks, Mr. Schulman. You're at 6.5 minutes.
Okay, I got another 2 minutes. I'm not going to the merits of this. I'm going to your comments about process. Okay, there's a comment made about the FAR and the interior of the building, and you know whether the planning commission as part of these site plan developments should even consider FAR. Well, first of all, let me say in the beach walk case, which I was involved in as a planning commissioner, we were given very specific numbers about FAR, and they were important numbers. And there was nothing on the face of that application that indicated that what they told us about FAR was at odds with the plans that they actually submitted. Were there staircases shown? No. But there was nothing to indicate that their statements about FAR were incorrect. Fast forward to this case. FAR is not just a zoning matter, whether the building can be built that is as proposed. FAR in this case affects the whole question of parking. Mr. Weber said, oh, it's only a couple of one way or another, you're not going to be tweaked. Well, we don't know if it could be tweaked based on what Mr. Patterson said. But more importantly, this building, clear space, was like 40 feet under the required, under the FAR limit for whether parking's required. And you approved this?
Mr. Schulman, we're now at 8 minutes. Let's wrap it up, please.
Okay, I'll make one more comment. I wish you all, many of you who haven't, would educate yourselves about the code. It was a joke when I heard people say, well, why do we need to put anything about lighting in our approval or limits on lighting? Because the zoning code takes care of that. Why are we doing these things? Guess what, folks? Except for signage, the zoning code says 0 about lighting. The zoning code says 0 about lighting. But you all thought it wasn't necessary to really think very much about the lighting issue because it's in the zoning code. I would suggest in terms of process that you all be familiar with the zoning code before you start making comments the way they were made. Thank you very much. And I do hope that you get real professionals who can help you last time, because I'm sad to say, although I believe you all did your best, and I don't believe any of the planning commissioners had any kind of bad motive or intent here. You're good people, but this was a big screw up for all the reasons stated by Mr. Patterson, Ms. Lucier, and Mr. Strange. Thank you.
Thank you, Mr. Schulman. Now, I don't have anyone else on my list, but I see that Miss Julie Davis is still on the line. Miss Davis, do you want to say anything?
Yes.
Wonderful. Go ahead.
Yes, I would. And I had sent in comments and a request to be added to the speakers list on Wednesday, so I'm not sure why I'm not on the list.
Yeah, I remember. I remember answering that email. My oversight.
Yeah, I was going to say, well, I didn't mention that I got the email from you, but I did.
That's okay. Please proceed.
I would like to make just 2 short technical points. about the proposed finding in the draft resolution that has been deleted by the commissioners, but I think it's important, and I'd like to supplement the discussion that the commission had with some additional information. That proposed finding would have stated that the proposed educational related services, such as the Arts Institute, described in the applicant's traffic evaluation report dated August 11, 2020, is an accessory use and is compatible with primary use. According, however, to that traffic report, the Spotlight Theater activities are going to be limited to late night, hour-long, small audience, adult entertainment in a very small space on some Saturday and Sunday evenings during the summer. And they're going to be provided by theater companies that are unrelated to ClearSpace. These sporadic theater activities are clearly an incidental use of the Spotlight building and appear to have been included in ClearSpace's plans for the sole purpose of avoiding parking provisions in the zoning code. In contrast, the description of ClearSpace's Arts Institute that are also included in the traffic report, as well as on ClearSpace's website, show that the primary use of the Spotlight building will be the conduct of the Art Institute's educational services. They will include numerous and various classes and programs regularly scheduled for after school and in the evenings throughout the year and on a daily basis during June, July, and August. In fact, according to TST's website, over 500 students were enrolled in over 100 ClearSpace Art Institute classes, class sessions, and programs in the Baltimore Avenue facility in 2019. This is not an incidental use. Second, regardless of whether the Art Institute is an accessory incidental use, the use provisions of the C1 Tier 3 zone do not include education-related services. Those services are defined in the provisions of the ER zone, which requires such services, such as organized schools, school offerings of classes in arts, music, dance, etc., undertaken as a commercial venture outside the usual progression of formal education, to be located as a conditional use within a school building that existed as of July 1st, 2010. Moreover, if Spotlight were considered an educational facility, which I think it should be under that definition, public and private schools are uses that are only allowed as special exceptions in the tier 3 of the C1 zone. In sum, the facts of this case clearly show that ClearSpace's educational services are not an incidental accessory use within the Spotlight building, and they're also not a permitted use in the C1 Tier 3 zone unless the Arts Institute is an approved conditional use as an educational facility or school, which in turn is a use that has to be approved as a special exception in that zone. So, bottom line, given these zoning code provisions, and they could not be clear, any finding that the education-related services to be located in Spotlight constitute an accessory use that would be permitted in the zone in which this building is to be located would be clearly erroneous. Thank you.
Thank you, Ms. Davis. So I think that takes care of all the comments. We'd like to thank everyone who commented today. We appreciate hearing from you. And I don't think there's any other matters before the Planning Commission. Remember that. Oh,
one more thing, Mr. Chair. So Mr. Schulman asked about the appeal period.
Oh, thank you.
The code doesn't give a clear date as to if in this situation where a resolution is going to be revised and finalized, it doesn't give a clear indication as when the period to appeal starts to run. So I would suggest that when the resolution is complete and loaded to the portal, whatever day that is, the period should run from that date. And we will give Mr. Schulman the courtesy of sending him the final resolutions when they're done.
Wonderful. Thank you so much for that clarification, Mr. Mandelis.
Okay.
I'm making a note. Okay, Great. So we have some hands up. Why don't we go to Mr. Kaufman and then Mr. Strange?
I'd like to make sure that some things are clear. When the record was closed, it was closed for, at that time, there would be no more public comment on the record. And so the comments today are not part of the record from the public and should not be part of the record. Our deliberations are part of the record. So once the record was closed, it was closed as to public comment, and it was closed as to the applicant, unless we asked the applicant to put something else into the record, which the applicant has agreed to do. So the comments after our decision was made should not be part of our record going forward, because those comments should have been made at the time that the citizens who were opposed to this application were entitled to speak. Plus, just about everything that was restated after we finished was already commented on during that period of time. And we've tried to close this record several times. So I think it's pretty important to recognize that there are different parts of the record. The first part was the public record, which was made up of the application and those things submitted by the applicant and the public. Our deliberations are always part of the record that goes forward. But the comments that we've just had for the last half hour or so are not part of the record and should not be forwarded as part of the record. This case may very well go on to appeal both to the commissioners and to the courts. And it's very important what is appropriately in the record and what is not appropriately in the record. Then I had one other thing. It's clear that Jan Conacy and I are not in total agreement on things. I also believe that Rehoboth is unique. The fact that it's a small space, just 1 square mile, doesn't constitute whether it's a city or not. What constitutes whether it's a city or not is whether it functions as such. And during the summer months and even on some of the other months, this city has tens of thousands of people in it, which clearly are the kinds of things that a city has. And clear space is one of the cultural aspects of that, which gives it its unique identity. And so I think that we, the Planning Commission and the commissioners and the people who live in the city and who come to the city have to realize we're now in the 20th century and that the forces on the city for further development and so are not going to go away. Deal with them in an appropriate way. We need to have a good zoning code. We need to have a really good CDC. And I agree with you and others who have commented, we need a professional planner or a professional, with a professional vendor who's able to advise us either through a contract or through a permanent person who's a planning commission, who's a planning director with the appropriate background. These pressures are not going to go away. We need to face them because otherwise we're going to be in bad shape here. So thank you for letting me say those things.
Thank you, Mr. Kaufman. Mr. Strange, you were going next? Please go ahead.
I just had a question to Glenn, since this has been a complex process, and the motion that we some of this disapproved of, but has been approved, is going to be reprocessed. We're not voting again on that. We're just getting it for clarification to make sure all the I's and T's are correct and what we think we voted for, we actually voted for or against. Is that correct?
That's absolutely correct.
Okay.
Any other comments? Well, again, I'd like to say thank you to everybody involved, the applicant, the public, the Planning Commission, the city staff. You all make this possible, and I'm pleased that we've brought this to a closing today. So thank you all for your efforts. And if there's no other business to be brought forward, I think someone should make a motion to adjourn. Mr. Bryan looks like he made a motion. Mr. Strange seconded. So all in favor of adjourning?
Aye.
Okay, on to March. We'll see you at the next regular meeting for the CDP.
Thank you.
Thank you.
Thank you.